My lord, I am seeking leave to mention an urgent listing, Your Honor.
Urgent?
Urgent listing of an application. It is against an identity model refusal.
Yes, yes,
But-
hand over.
Much obliged.
Identity order.
Please.
I was praying that the matter appears
Pardon?
tomorrow. I was praying that the matter.
Whenever the file comes, it will be listed. What is the hearing not now?
Which on the heading application, my lord.
Yes.
First
Appeal. Hearing application. Yes, yes, please. Withdrawal, yes, to be mentioned. Mr. Charles, you will take your
application.
yes.
Lordship, may I take leave to mention one matter? Lordship, my matter was supposed to be appeared today. Lordship, there is an appeal, FMAT 485, but it was supposed to be up, but it is not in the list.
Please hand over the slip. We'll check up definitely.
I have a lordship's leave to mention one matter for listing as application.
Yes.
Lordship,
I left the appeal pending since 2017. Senior citizen.
Appeal hearing? Not right now, ma'am. Wrong slip. Yes. Done. অনিন্দিতা কি হলো? দেখে নিচ্ছি। Yes, from the report of the Assistant Registrar dated November 20, 2024 that proper Vakalatnama was not filed on behalf of the respondent number 1, full stop. Also, comma, the learned advocate for the appellant has not yet filed requisites for effecting service of notice of appeal upon the respondent numbers 2 to 4 by speed post with AD, full stop. The learned advocate for the appellant is directed to file such requisites within January 3, 2025, full stop. In default, comma, the matter be placed in the list on January 7, 2025 under the heading Lozima for final orders. Lozima for final orders, total term within one inverted. Lozima okay. Yes, Mr. Dhar, what is the matter?
Number restoration application and the application for condonation and
We have a predicament in appearing today because just now I am coming from room number 2. There has been a resolution that on account of the death of a member, we will not participate in the judicial proceeding.
From 10:30?
That is there, and the body will be here. That's why, my lord, though I am here, if it is possible, can it be taken up tomorrow? Otherwise, my lord, as a member of the bar, I think it's okay.
We'll take it up tomorrow, Mr. Dhar. We'll
heard about the meeting, but
I'm coming.
result of the resolution.
this is coming from there, so
Only make it not.
resolution has been taken. Very well. On the prayer of the respondent, the matter is adjourned for the day.
For the day.
D.
The same position in the tomorrow. I'm deeply obliged.
Yes. That is সারাদিন গেল।
Name should not be taken up today at least.
No, we have recorded that you have paid for time. We have said that.
We have resolution, my lord.
No, you are not appearing. You are asking for time. Protindana Nara. Respondent
Respondent number 3.
Respondent number 3. None appears for the parties at the time of call. Let the matter stand adjourned for the day. এই অর্ডারটা অনেকগুলো কপি পেস্ট হবে আর কি।
For the appellant, my lord, this appeal was initially allowed by this honorable court, my lord. The respondents have preferred an appeal before the honorable apex court, my lord. And honorable apex court was pleased to set aside the judgment and decree passed by this court, my lord, directing this court, my lord, to reconsider. Now, my lord, that appeal was when disposed of, my lord, was at the stage of application. So, my lord, there was no LCR called up and other things, my lord. This application, my lord, is, my lord, praying for, my lord, bringing LCR, my lord, and for, my lord.
Did you put in requisite deficit?
No, my
court
lord,
fees?
I'm praying for that direction, my lord.
Very well.
Is there,
So, what is the application for?
my lord, this is, my lord, the application for, my lord.
Appropriate or
Yes, for
all
bringing
those
LCR
necessary.
through special.
You are appealing for which of the respondent?
One respondent. There's only one respondent.
Well, so we'll dispense with service of notice only. We find from the records that deficit court fees of rupees 39,980.
It has already.
It has been put in.
Yes, already, my lord.
Then you say that you ask for time
No,
for.
No, I've prayed for, my lord, direction for, my lord, bringing LCR through special messenger cost and, my lord.
You have paid more than 20
Yes.
rupees more.
Yes, my lord.
Very well. We find from the records that the deficit court fees have already been put in, and as such, the defect is cured. First up, learned counsel for the appellant submits that the appeal had been previously disposed of by a coordinate bench. First up, the matter thereafter went up to the Honorable Supreme Court, which set aside the judgment and degree of this court and send the matter back to this court for hearing. First up, next para. In view of the innocuous nature of Can 2 of 2024, we take it up for hearing. Full stop. The Can 2 of 2024 is disposed of by directing the appellant to put in the necessary requisites. Full stop. However, service of notice of the appeal on the respondent is dispensed with in view of appearance of the respondent through her learned advocate. Which of the next para, the trial court records be called for by special messenger at the cost of the appellant, to be deposited within a week from date. Stop. The appellant shall prepare and file the necessary number, the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to the parties to mention for enlistment as and when the appeal is made ready for hearing.
Grateful.
Yes. Yes, for the parties at the time of call, full stop. The appellant shall cure the defect by incorporating the expression within double inverted appeal from original decree, double inverted clause, in the caption of the memorandum of appeal, full stop. Necessary amendment in that regard shall be carried out by the learned advocate for the appellants within a week from date, full stop. The appellants shall serve a copy of Can 1 of 2024 on the respondents, indicating that the application shall be listed for hearing on January in the monthly list of January 2025. মেরিটে কিছু অর্ডার দেবো না আসলে যদি না
I for the respondent, I have served the evidence in opposition upon the other
What
side.
is this? Everything in operation.
It's not yet ready, my lord. Kindly takes up.
What is the application for?
Application is for, my lord, there was an order passed by Justice Mukherjee saying that if the extra royalty and all is not paid to me, then I shall file for injunction. That has not been paid to me since last November. So that is why I've made an application. I've taken out this application.
This is Can 2.
Yes, can too.
Here allegation, my lord, is that we have not paid the ad hoc royalty payment as per direction of the, my lord, sorry, one copy I have
Should have filed another copy. Where is another copy?
in course of this, my lord. Kindly allow me, my lord.
No. File 2 copies together. Learned counsel for the respondents seeks to file affidavit in opposition, full stop, however, comma, since 2 copies of the affidavit in opposition are not available with the learned advocate, comma, the same is not taken on record, full stop. The respondent shall file the affidavit in opposition on the next returnable date. Full stop. On the prayer of the appellant, comma, the time for filing affidavit in reply is extended for a week from date. Full stop. The application shall be listed for hearing on in the monthly list of January 2025.
My lord, I have heard.
No, need not. You file it on the returnable date. You have given a copy to her. Yes, we are saying that only.
Lordship, I'm appearing for the appellant's petitioner. I'm praying for not today as the senior counsel had a family emergency. He had to leave early.
Should have mentioned it. Should have informed me, sir. He would not have come.
This is very all of a sudden.
Under these situations, just mention it. Inform the other side. So they would not have
responded in this matter.
Yes, you should have been. They should have informed you anyway. On the prayer of the appellant, the matter is adjourned for the day.
Lordship,
Tomorrow.
Lordship, may I file the affidavit in reply to their
No. Come back on.
Copy.
I have served the copy on.
You have filed your opposition.
I have not filed, my lord. It is ready.
So we'll take it up tomorrow.
Tomorrow I'll file.
যেটা বললাম adjourn for the day on their appellants. Mr. Dev, who is appearing with you, please ask them to give the names.
Names, please. Let us see.
Yes.
The 8th, my lord, I am for the appellant. My lord, I am challenging a divorce decree wherein I filed an application for stay. They have come up with an opposition, my lord, to say that, my lord, they got
Married.
married. My lord,
They're
in Arjo Samaj, my lord, rituals. And therefore, my application, my lord, for stay has become infructuous as of today. In my reply, my lord, I have said that, my lord, the marriage that they have my lord, claiming to have undergone.
Don't have a.
Huh? Reply, Dani?
No.
No,
My lord had given, in fact, 2 directions where.
yeah, reply that Jama Kudisni Baba.
Has not been filed, Mr.
Yes, my lord, opposition.
Has been filed.
Yes, occasion file.
Evident.
Opposition টা কোথায় দেখুন?
Huh?
Affidavit opposition.
তোমার advocate takes it up on the next day, my lord. But I am filing my reply.
আচ্ছা,
But I'm sorry, my lord, the copy was not, my lord, given.
the affidavit in reply filed today be kept on record, pushed up. Since no copy thereof has been served on the respondent, comma, let a copy be served during the course of the day, pushed up. The matter shall be, the application shall be taken up for hearing when, because you get the copy today. If you want tomorrow we can
Tomorrow, my lord, if it's convenient.
let the matter be.
Just have a look at the reply.
Very well.
But
Let them,
instead of tomorrow, let it be day after tomorrow.
day after tomorrow we
Oh, that is a single bench day. Then Monday, my lord.
Monday.
be listed on December 16, 2024.
Lords.
Sorry, the 23, 2024, December 23rd.
December.
Copy take.
Thanks.
I'm appearing for the appellant in this matter. Your lordship on 4th December, 2nd December, my lordship passed an order. Lordship will kindly seize, my lord. There was a direction for service to the husband. My lord, we served in spite of service. They did not appear, my lord. And my lord, liberty was given to me to file an application for my lord, appreciation of the maintenance amount. This is
Application maintenance.
maintenance amount. So my, this is that application. Lordship will kindly take, my lord. This is a can 2. So previously, my lord,
You have to file your affidavit of assets also. Now,
I have already declared, my lord, 12,750.
where?
Lordship will kindly take, my lord. He's a para teacher.
No, Mr.
Para 9.
Chakrabarty. You have to follow the format of Rajnish.
Yes, I have. Then, my lord, let there be a direction of service, my lord. Their husband also, my lord, file it, my lord, because I am only, my lord, already I am getting 20,000 rupees.
Whatever you are getting, you have to file an affidavit of asset in that format. So we'll direct you to file that. How soon can you prepare that?
Well, after 2 weeks, within 2 weeks, you can follow. And then it can be, my lord, appear after vacation.
None appears for the respondent husband at the time of call, full stop. The present application bearing can 2 of 2024 is an application for enhancement of alimony pendentility. Full stop. The appellant stroke petitioner stroke wife is directed to file her affidavit of assets within a fortnight from date. Within a fortnight will not do. Within January 3, 2025, full stop. A copy thereof shall be served on the respondent, and an affidavit of service to that effect shall be filed in court on the next returnable date. Full stop. Affidavit in opposition to the present application, as well as to the affidavit in opposition to the present application, as well as the affidavit of assets of the respondent husband, shall be filed within January 17, 2025. Full stop. The application shall be listed for hearing on January 20, 2025.
This application I am not required to serve.
Oh, application you have not served.
No, because it was.
Copy shall be served. Copy যেখানে বললাম?
Yes.
Copy of the application as well as the affidavit of assets shall be served. তারপর judge.
Well, only one prayer. If instead of 3, it can be made 5th or 6th.
আচ্ছা, তাহলে পুরো টাইমলাইনটা চেঞ্জ হবে। যেখানে জানুয়ারি 3 আছে সেখানে জানুয়ারি 10 করে দাও। আর opposition as well as affidavit of asset of the husband by January 24, returnable date January 27, 2025. 27 January. আপনি একটু নোট করে রাখবেন কিন্তু এটা কবে রিটার্নের।
Appear for the appellant, my lord. His application is appearing for first time, application for stay and injunction restraining husband from remarrying, my lord. Initially, I filed a suit for divorce, my lord. Husband entered appearance. Thereafter, he filed written statements as well as a counterclaim. I filed an application on Section 24 alimony. Thereafter, terms were going on.
You filed a restitution suit?
No, Section 13. Thereafter, my lord, for the talks of compromise, I did not appear in the suit. My suit was dismissed for default. After a period of 13 months, husband filed an application for recalling of his order of counterclaim. Without serving me, that
counterclaim was also dismissed.
Counterclaim was also
dismissed. What was the counterclaim?
For divorce only.
Both of you filed for divorce?
Both. Thereafter, that counterclaim, after a period of 13 months, my lord, that counterclaim revived without serving my notice. That proceeding went on. Suit was made ex parte and decree was given ex parte, challenging which have come up before this court, my lord.
The present appeal has been preferred against an ex parte judgment and decree allowing the counterclaim of the respondent husband for divorce. Full stop. Next para. Being satisfied about the prima facie case of the petitioner for the appeal to be heard on merits, comma, we are inclined to grant addendum injunction. So accordingly, the respondent husband shall remain restrained by an order of injunction from contracting any remarriage during the pendency of the application. Full stop. The petitioner shall serve a copy of the application on the respondent, indicating that the application shall be listed on January 20, 2025. Full stop. Affidavit in opposition, if any, shall be filed by January 10, 2025, and reply thereto shall be filed by the next returnable date. Full stop. The petitioner shall file an affidavit of service on the next returnable date.
DP of
দিয়ে করে নিলে তো ইন্টারপ্রেট হয়ে যাবে। Yes.
But I am for the appellant. Blood on 4th of December, your lordship was pleased to pass an order directing my learned friend blood to file an opposition blood on the point of occupational charges.
Yes.
This was blood. My learned friend has come up with an opposition blood. Their blood, the rate that they are showing is blood 137 rupees per square feet. The blood, we have filed our reply to say that that is blood. This is a very old house.
Reply to
And blood that the reply.
Yes.
Reply. And that blood, it cannot fetch as of now, blood, the amount that they are seeking for, blood. So, blood, as of today, blood, I am not averse to paying an occupational charge, blood, which is a requirement under blood law. Now, blood, the amount, blood, that your lordship will kindly, blood,
What was the
would
last
not be more than blood 100 rupees. That much I must say.
per square feet?
Per square. It's a commercial building used for commercial.
If it's 100 calculated as 100, what would be the what is the area?
No, that is 5,000 square feet. Blood, it will be 5 lakh.
on Shakespeare Sharon.
Expression. So it's a resident you are
No,
using.
blood, it is a commercial building, old commercial building. And blood, my amenities are blood that are being curtailed. I'm told on instruction blood that blood the electricity is supplied through a submitter. And I was supposed to pay blood the electricity based upon the submitter reading.
Now disconnected.
No, not disconnected, but they are not accepting blood the money blood that they are supposed to blood get from for my use of the electricity.
Mr. Mukherjee, let us hear Mr. Banerjee first on his
Very well.
occupation charge argument. Then we'll come back to you.
Judge.
Yes, Mr.
Kindly
Vance,
take my opposition once. This opposition is restricted to only this occupational charges.
Yes.
My lord, will kindly turn to page 31. My lord, this is a report, my lord, which we have got from an expert. Kindly turn to the nature of the property. Page 31, internal page 2. I'm sorry.
Yes.
Page 31, my lord, the property details are given. My lord, will kindly take the location of the property, my lord, at the bottom of my lord, page 31. And kindly also take note of my lord, serial number 16 and my lord, serial number 13. My lord, 12, 13 and 16 my lord, may be of some relevance. Then my lords will kindly turn to the next page. Kindly, my lord, have a look at serial number 7 once. My lord, that it is a commercial building, my lord, that is now, my lord, admitted. I am not troubling your lordship by showing that. Kindly take, my lord, serial number 7 once. Kindly see, my lord, the boundary where the property is exactly located. Then, my lord, serial number 11, my lord, is the estimation. My lord, but that was, my lord, on higher side. My lord, ultimately, my lord, the valuer, my lord, has on a conservative estimation, my lord, indicated what should be the rental value. Then, my lord, kindly have a look at 12 also. This is, my lord, the circle rate, my lord, which is, my lord, otherwise uniform, my lord, in that particular locality. And my learned senior friend, my lord, was suggesting that, my lord, this is a old, my lord, property, which, my lord, will get an answer in serial number 15. My lord, at page 32. And my lord, the covered area, my lord, will get, my lord, at the bottom of page number 32. Kindly, my lord, turn over the page then. My lord, part 2, my lord, is valuation. My lord, he says prevailing market rent of similar type of commercial space on carpet area in locality varies from 152 rupees to 320 rupees. We consider the value of the aforesaid unit at 152 rupees per month on a conservative basis. So, my lord, according to our valuer, my lord, this cannot go below, my lord, 152 rupees per square feet.
Now, this is on the carpet area. So, what does it Covered area is
It's
5,000.
Milord 5,000. Covered and carpet, Milord, it's 5,000.
Covered and
It's not
carpet is
super
the
big.
same.
Yes, Milord. That's Milord my instruction is.
So 152, how much does it come to?
Milord, I'll just check it.
152 into 5,000?
Milord, it ultimately, Milord, he has calculated. Milord, kindly take the next paragraph then. Consequently, which starts with consequently at Milord the same page 33. Consequently, the present rental value as on is assessed at rupees 152 per square feet on carpet area per month, which corresponds to 137 per square feet on built up area, Milord.
What will be the total? 152?
Yes, Milord, 6.85 lakh, Milord, he has calculated.
Where is that?
Milord, page 35, if Milord's kindly turn to.
Yes.
And
What was the
Milord,
last?
he has drawn
Yes.
an
What was the last rent paid?
100 rupees still over there, no? 5,000 rupees.
Total 5,000. When was the tenancy given? Do you have any idea?
1973, Milord, the tenancy he was inducted.
It has been the same since then.
Yes.
The rate.
This was under a registered lease.
Any other document to support?
Yes, Milord, he has referred to that at page 34. Milord, there are two references, Milord, he has taken note of.
Yes.
Milord, reference 1 and reference 2. Milord, 1 is lease deed of 2023, Milord, a sent document. Because, Milord, occupational charge should be, Milord, of the present market value. Milord, he says, Milord, it was 125 square feet of carpet area, which corresponds to such and such super built up area. And, Milord, the monthly rent is 40,000. Milord, at the rate of 320 rupees per square feet. The next one is, Milord, 152 rupees per square feet, which corresponds to 122 per square feet, Milord, on super built up area. In our case, Milord, he has calculated it at 137.
In the same premises?
No. Oh, same, yes.
Same in
Milord,
the subject premises?
Same.
So these documents are there, these references?
Yes, Milord, these are, Milord, annexed.
Very well.
Milord, page, yes, that.
Very well. Let us come to
Milord, page 40, page 40,
Yes.
Milord, which pertains to IDP. IDP, Milord, is
Very well. If the documents are annexed here, unless Mr. Mukherjee opposes. Let us hear Mr. Mukherjee now. Yes, Mr. Mukherjee.
Now, my lord, so far as these two documents which forms the basis of their claim, my lord, at 137 rupees per square feet,
Yes.
my lord, these are, my lord, executed by the landlord, my lord, in respect of, my lord, the tenants, my lord. Therefore, my lord, it can be in all probability, my lord, on the higher side as of today. My lord, I'm an absolutely old tenant. I was a leaseholder. And, my lord, my landlord is himself, my lord, a leaseholder, which will transpire from the document at page, my lord, 31.
How does it matter as far as you are concerned, Mr. Mukherjee?
Lord, all that
You are
I
a
say
tenant
is
under
that
him.
no, I do not say so. Lord, it is not that, Lord, that he is an absolute owner of the property, and therefore, Lord,
Absolute
he
owners
is also
get more rent.
it is not that.
Unacceptable.
Well, Lord, my next point of argument is, Lord, kindly come to page 33.
Yes.
Sorry. Yes, your opposition.
Yes. We are on the opposition only.
Now, Lord, the page 33, my learned friend has pointed out, Lord, that the finding is consequently the present rental value as on assessed for 152 per square feet on carpet area per month and corresponds to 137 per square feet on built up area based on market inquiry and reference from lease deeds. Now, Lord, your lordship will kindly see, Lord, the page 32, the last, Lord, the entry 17A is, Lord, the covered area, and there is no reference to, Lord, the carpet area or the built up area.
According to you, also 5,000.
It is 5,000. I am not disputing.
Is a carpet area.
But it is, Lord, they are saying in their opposition, they are claiming, Lord, 137. So 137 is the rate that they are claiming, Lord, on the 5,000 square feet. I'm not
Carpet
going
area,
into
they are
the
saying
dispute
150.
whether it is a covered
Carpet area, they are saying Super built-up area is artificially added to that.
That is a the amenities area included.
Yes,
into and
exactly. That is also included. So
Those
super
are
built-up
not
is
the-
not a standard. Mr. Mukherjee, don't argue further. You cannot.
Lord.
You are incapable.
Very
Because of your
well, Lord.
gentle,
I'll
because of your
leave it to your
gentleness,
lordship,
you
Lord.
cannot argue with the ferocity of certain others. So you're a senior advocate. Stop there. We'll grant.
I'm
this.
grateful for that. But I'll just request your lordship, Lord, to be Lord bit temperate with Lord the amount of Lord the occupational charge.
685.
That is my
See the
request.
area,
That-
Mr. Mukherjee.
But I have seen it is commercial area.
The boundaries also.
But Lord, it is not
in the thick of the commercial area.
not Lord the building, Lord, as on instruction I say on Lord the Shakespeare Sharoni. It is a building abutting Lord the AC market.
Yes, the boundaries are given. Not on the Shakespeare side.
Oh, I stand corrected, Lord. It is a building, Lord. in
Yes,
the
yes.
AC market.
Please continue. Continue.
No, Lord, I am.
Learned Senior Counsel appearing for the what is it? Learned Senior Counsel appearing for the appellant stroke petitioner contends that the Mr. Banerjee, please take your seat. That the proposed occupation charges as projected in the affidavit in opposition is on the higher side compared to the age of the building, which is quite old. Push up, it is further submitted that although the report of the valuer annexed to the affidavit in opposition mentions the covered area of the suit premises to be 5,000 square feet, no corresponding valuation of the covered area is reflected from the rest of the report. Push up next para. It is further contended that the respondent landlord itself is a lessee in respect of the property and not the absolute owner. Push up. Moreover, it is argued that the petitioner is deriving electricity from a submeter. Full stop. Next para. Learned counsel appearing for the respondent places reliance on the annexures to the affidavit in opposition. Full stop. By taking the court through the relevant entries in the report of the valuer annexed to the affidavit in opposition, it is pointed out that the location of the suit premises is a commercial space on 8th floor at premises number 3 capital A Shakespeare Saroni, post office Middleton Row and police station Shakespeare Saroni, Kolkata 7,71,000. Full stop. The covered area, it is argued, is equivalent to the carpet area, for which the present rental value is assessed by the valuer at rupees 152 per square feet. Full stop. The premise of the said report was two separate deeds of tenancy, subtenancy granted by the respondent to other tenants under the respondent. Full stop. The said it is evident from the documents pertaining to such tenancies and the corresponding entries in the valuer's report that the current rental in the area range between rupees 320 per square feet on carpet area and rupees 152 per square feet of carpet area. Push up. Upon hearing learned counsel, we find that the two other premises, the rent of which has been taken into consideration by the valuer, are located on the self-same building as the suit premises. Full stop. Even the circle rates as per the government gazette website shows that the current rate per square feet on carpet area in the neighborhood of the suit premises is rupees 20,440. Full stop. However, the valuer, fairly, has based his report on the basis of the current rentals being paid by other tenants and has arrived at the conclusion that the projected rental value for the suit premises is assessed at rupees 152 per square feet. Full stop. Next para. Upon a careful consideration of the documents annexed to the affidavit in opposition,
It's 35, my
Sorry, thank you, Mr. Is rupees 137 per square feet. Full stop. Next para. Upon a careful consideration of the documents annexed to the affidavit in opposition, comma, we do not find any infirmity in the report of the valuer, comma, which is based not only on the current government rates, but has taken into consideration, comma, quite correctly, comma, two other tenancies located in the same building. Full stop. The test for grant of occupation charges as condition of stay in respect of eviction suits is the rate at which rate which could be fetched by the suit property at the current market rates at the present moment. Full stop. The principle behind it is that in the event the decree holder could obtain possession, comma, but from the stay order operating by virtue of the order of this court, comma, the same could have been rented out at such current rates. Full stop. Next para. We are of the opinion that the fact that the respondent himself is not the absolute owner, itself is not the absolute owner, is not of any relevance in the context, comma, nor is the fact that the appellant may be getting electricity from a submitter. Full stop. Also, comma, we find that the building is located in a prime commercial area of the city of Kolkata, and that the age of the building is not much, comma, being about 40 years old. Full stop. Hence, comma, taking into consideration the amenities available in the area and the current market rates prevalent for other tenancies in the self-same building, comma, we are of the opinion that the rate projected in the valuer's report annexed to the affidavit in opposition by the respondent is the justified current market rate. Full stop. Accordingly, Can 1 of 2024 is disposed of by granting stay of operation of the judgment and decree impugned in the appeal till disposal of the appeal, comma, subject to the appellant paying occupation charges at the rate of rupees 6,85, 000 per month to the respondent. Full stop. Next para. The arrear rents from the date of the eviction decree passed by the court below till the month of December 2024 shall be paid by
Paid or deposit?
no paid. We'll record also that this will be subject. They'll get it subject to the undertaking that they'll refund if you win the appeal.
Put them to terms then. Lord.
We will put yes, like Attaram.
Very well. And Attaram is deposit.
There are other judgments
Attaram
also.
by-
Some of the judgments say that they'll have to return.
Your lordships have passed not judgments to same lord that they will be getting the money, the landlord, I mean to say. But
Yes.
subject to terms. In the event of my success, lord, this money should come back to me.
That is precisely what. Very. Till the month of December 2024 shall be paid by the appellant. What would be the arrears? Mr. Mukherjee will quite an amount. Quite.
But sir,
24th June is the
it
date
is
of the
6,85,000 per month according to their calculation, isn't it?
36 around 40 lakhs.
40 lakh.
Around 40 lakhs.
You can pay that.
6 মাস 6 6 36
হ্যাঁ
85 লাখ হাজার করে আরো কাছাকাছি 40
We'll give you till January 15.
Well, give us some installment, lord, we'll clear it off. We'll clear it off. Kota.
40 lakh. 40 lakh. We are giving you in January instead of installment.
Because of the jute industry is not, lord.
This jute industry.
Yes. And
Oh, yes.
so, lord, and lord, so far as lord, the electricity, lord, kindly direct them that they do not lord, disconnect subject to the payment.
Not actual
Yes,
on
we are
actual
always ready to.
on actual
We will look into that first. Let us say. We'll give you 2 installments, Mr. Mukherjee. By 2 equal monthly installments, comma, the first of which shall be paid by January 15, 2025, and the second by February 15, 2025. Full stop. The current monthly occupation charges from the month of January 2025 shall be paid by the 15th of each current month, comma, the first of which shall be by January 15, 2025, and thereafter by the 15th day of each succeeding month. Full stop. Next para, it is made clear that in the event of default of any of the above payments within the timelines as stipulated above, comma, the interim order of stay granted by us shall stand automatically vacated without further reference to court, and the respondent shall be at liberty to proceed with the execution of the impugned decree. Full stop. Next para, it is further made clear that in the event the appeal is it is further made clear that the payments so made in terms of the above directions by the appellant to the respondent shall be subject to final orders passed at the time of disposal of the appeal, and it is also clarified that in the event the appeal is allowed, comma, appropriate orders of adjustment stroke refund of the said money can be passed by the court taking up the appeal for final hearing. Full stop. Next para. The respondent shall also ensure that the amenities being provided to the appellant shall not be curtailed, comma, including electricity, comma, subject to continuous payment of the current occupation charges, as well as other charges such as electricity charges, which, comma, according to the previous agreement between the parties, are payable by the appellant. This much.
Two things, Milord. The building is 50 years old instead of 40 should be.
Your report says 40.
No,
No,
40 is
but I
the
read it
balance,
wrong.
Milord,
Milord, I read it
90
wrong.
years
Can-
age of the building.
একটা জায়গায় 40 বলেছে, ওখানে 50 বলেছে।
And there are three references to Milord the same building.
Three tenancies.
Three tenants. Instead of two, Milord, it would be three.
The range is 320 to 152.
Yes, yes, same. Milord 34, there are two references. Page 35, there is Milord the third
একটা
reference.
কথা বলেছি ওখানে। না, the report refers to 3.
Three.
Oh, yes. একটা জায়গায় বলেছি refers to 2, হ্যাঁ, ওটা 3 হয়ে যাবে। দেখে নে করে দেব। আচ্ছা, we'll pass the usual directions also regarding paper books and all. The appellant shall, in view of the appearance of the respondent through their through its learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court record shall be called for by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
And the application is this one.
Yes, the first line was that. Can one of such and such is disposed of by. These two litigants probably have 1000 litigations in the High Court. In every list, then.
These are rental properties. The landlord, he rents out the entire building, the AC market.
Yes, that's his income.
That is not the way of earning.
Yes, next matter is also yours.
But it is that matter wherein, Lord, in a partition, Lord, a suit, Lord, the learned judge held that I could not produce any document of ownership, although I've inherited the property, Lord, through an ancestry, and rejected my, Lord, the plaint. I mean the suit.
Dismiss the suit.
Dismiss the suit. My learned friend was there on the last occasion. Lord, I pointed out before your lordship, Lord, the last page, the second last page of the impugned order. The only reason, Lord, the learned judge holds, Lord, this is a property which has been inherited by the parties. Then, Lord, at the second paragraph, now at the time of argument, the learned advocate appearing on behalf of the defendant stated that the share as claimed by the plaintiff not properly proved by documents. Learned advocate submitted that only tax receipt cannot be the proof of the title. From the loopholes of the defendant, plaintiff cannot get any decree. If for argument's sake, it is a hold that the defendant admitted for one property and the plaintiff pray that property, then also without producing proper document, right, title and interest over the property cannot be declared. Here in this suit, the plaintiff failed to file any document regarding right, title and interest over the suit property. Without the document of right, title and interest over the suit property cannot be proved, still over the admission of the defendant, right title and interest cannot be declared. So in this respect, the plaintiff failed to prove her case. And my lord, in the body of the judgment, it is a case, my lord, that this is an inherited property. The defendants are the co-sharers. And my lord, the learned judge said, because of the argument of the defendant that I could not produce any document of title, my suit was not dismissed.
What were the exhibits? Some document, because otherwise
Yes,
you'll
the
get a
exhibit-
collusive suit and all.
No, my lord, it is not. My lord, why it is not collusive, your lordship will find, my lord, at the internal page.
Yes.
My lord,
9 are the
nine,
exhibits.
nine.
Yes, 9 are the
Nine.
exhibits. So original part of attorney means this is not relevant. Probably.
No, not only, my lord, my client was examined. And my lord, the defendant did not, my lord, adduce any witnesses. Then, my lord, the power of attorney, my lord, that was, my lord, from the mother to the daughter.
That is also
Joystree is the daughter, and my lord, my client is the mother.
Tax receipts.
In respect of this dwelling house.
Since when? Tax is for some. Only recent, or I mean.
No, not, this is not the ancestral property.
But there is nothing to show that it was his ancestral property.
No, it is admitted. These are admitted. You know,
Yes, should you dispute?
Kindly allow me, my lord, to
Yes,
place
yes, yes, Mr.
they place the judgment, because on the last occasion, my lord, I had placed it.
Yes,
but
yes,
my lord,
yes.
today I'll also.
Yes.
Lord, kindly come to my lord. Lord, paragraph 2A, that is at page, my lord, 2 of the judgment.
Yes.
The case of the plaintiff is that one Aboni Mohan Ghosh, since deceased was the sole and paramount owner of Bastuland measuring 3 kata, more or less together with 2-storied building standing thereon, lying and situated at KMC premises number 1/12, Rupchand Mukherjee Lane, PS Bhavanipur, Kolkata 25, which was acquired by him from his father Jyotindra Mohan Ghosh, which is more fully described in the schedule hereunder. Aboni Mohan got it from Jyotindra Mohan. That during the peaceful possession and or enjoyment over the said Bastu land measuring 3 katas more or less together with 2-storied building standing thereon, lying and situated as such and such, Aboni Mohan Ghosh died intestate on 9/5/59, leaving behind his wife, Shoibalini Ghosh, one married daughter, Uma Sarkar, the defendant number 1 herein, one unmarried daughter, Nila Ghosh, one son named Ananda Mohan Ghosh, one son named Alok Mohan Ghosh, one married daughter, Shobita Mitra, my client, the appellant, and one son, Arun Mohan Ghosh, the defendant number 4 herein as his legal heirs. So, my lord, your lordship will find, my lord, that the present parties are the legal heirs of Aboni Mohan, who got the property from Lord Jyotindra Mohan. After demise of said Aboni Mohan Ghosh, his wife Shoibalini, one married daughter, Lord, I am not reading, Lord, I am not that who died and how it evolved. Then, Lord, I am skipping over to the next page. During the enjoyment of the said property in HON'BLE, the mother of the plaintiff, namely Shoibalini Ghosh, died intestate on or about June 2004, leaving behind one married daughter named Uma Sarkar. Then, Lord, kindly skip over to the last portion, 1/6 share each in respect of the said undivided Bastu land. The brother of the plaintiff, Alok Mohan Ghosh, died intestate on about October 2004 during the enjoyment. Lord, then, Lord, the last paragraph of that page, it devolves to 1/5. The share is being, Lord, calculated. Then, Lord, the last line, now the plaintiff, Srimati Shobita Mitra, is the joint owner of undivided 1/5 share of the said undivided Bastu land, measuring about 3 kata more or less together with 2-storied building standing thereon, comprised of 4 rooms, 1 common hall, 1 common bath cum privy on each floor, totaling 8 rooms, 2 common hall, 2 common bath cum privy, and an asbestos shade room beside the staircase, a rooftop lying and situated such as. Owing to enlargement of the family and differences in the day-to-day life of the parties of the suit, since quite some time past, it became impossible to enjoy the suit property by the plaintiff, as well as it has also become inaccessible for her due to the serious obstruction created by the defendants. Times without number, the plaintiff has demanded the partition of the suit property more fully described in the schedule hereunder by metes and bounds, but the defendants are jointly and or severally refused to make the amicable partition of the suit property by metes and bounds in accordance with the legitimate share of the parties to the instant suit. Not only the defendants are refusing to make amicable partition of the suit property, but also they are not giving access to the plaintiff.
Mr. Mukherjee, can come to page 6.
Very
They stand. Because they say that moral is correct, but you have failed to file cogent deeds.
Lordship, but my lord, that is the ultimate conclusion of the learned judge. Then, my lord, the defense case is, my lord, at page 6. My lord, defendant filing separate written statement have stated that the suit is not maintainable either in law or in the facts, and barred under the principles of estoppel, waiver, and acquiescence, and misjoinder and non-joinder of necessary parties, and the same is false, speculative, baseless, and harassing in nature. With regard to the allegation and a statement made in paragraph number 1 of the plaint are more or less are correct, but I pause here for a moment. Plaint paragraph number 1 is all about blood that
Devolution, yes, we saw that.
But it is the duty of the plaintiff to prove the same by filing cogent title deed or deeds. Is their stand. Actually, the measurement of the land is 2 kata 4 chataks, more or less, that it is correct to say that Abani Mohan Ghosh died intestate on such and such, leaving behind his wife such and such. The legal heirs position has been admitted. That with regard to the allegation made in paragraph number 4 to 7 of the plaint are more or less correct, but anything contrary thereto and inconsistent therewith are hereby denied, and plaintiff is put to prove there. This defendant states that the share of the plaintiff in respect of the suit property as described in the plaint is not correct. It is denied. Thereafter also the denial portion is there. Then at page 7, it is their case that since after the marriage my client is residing in the matrimonial home, therefore I am trying to enter the property, I am not entitled to a degree of partition.
But have they disputed the shares in so many terms? They have just stated that the shares are not correct.
Because they are
but the line of succession,
the successor.
The succession they're admitting virtually the line of succession and the heirs.
My client is the daughter, and they are the sons. The brothers and sisters are fighting.
They are the sons. All the sons on one side and
But I am for the defendant number 4 only.
you are, but the respondents are all the sons.
Daughter
Yes,
is there.
yes.
Daughter.
Son, not the other siblings.
Kumar Sharkar is there.
So you have not opposed the line of succession, the heirship of these persons. So automatically the shares follow. Let us dispose of the appeal itself. Why keep it pending unnecessarily?
That is the reason it is appearing today.
But I am
Because
for
my
the
learned
defendant
friend
number the respondent number 4 only. The Lordship, my lord, if the Lordship so pleases, my lord, the other respondents, my lord.
We did it directly to serve on the others.
Well, I think my learned friend was
On caveat.
The caveat is
Actually,
No, you are on caveat.
I'm on caveat.
Then you have to serve the others. We'll indicate something in your order.
very well. But I'll
My lord,
serve
may-
and come back.
But only, my lord, the written statement, my lord, this paragraph has been, my lord, in there that it is correct to say that Abani Mohan Ghosh has died intestate on such and such, leaving behind his wife, Shoibalini Ghosh, and the others. My lord, it is practically admitted.
Yes.
Practically admitted.
Arun Mohan.
Last.
No, Anjan.
Only.
Anjan. But all can be served, Lord, by speed post, Kolkata.
Kolkata. So we'll keep it 1 week after the vacation.
Next week, Lord, your Lordship can.
Next week. Today we are on 18th. We have 5 more days. 5 days you won't be. Even Miss Dotto won't be able. With her expeditious. Learned senior counsel appearing for the plaintiff appellant contends that the learned trial judge, while passing the impugned decree of dismissal of the plaintiff apostrophe partition suit, erred in law. Full stop. It is contended that the defendant stroke respondents, in their respective written statements, virtually admitted the devolution of title in respect of the property, as well as the heirship of the parties. Full stop. However, the learned trial judge proceeded on the basis that no title deeds were produced in support of the plaint case, and as such dismissed the suit. Full stop. It is argued that in view of the virtual admission of the defendants, the suit ought to have been decreed in preliminary form and thereafter finally. Push up next parallel counsel for the respondent controversy submissions, respondent number 4, controverts the submissions of the appellant. Full stop. However, comma, on a bare perusal of the impugned judgment, comma, we find that certain salient features of the matter cannot be overlooked. Full stop. Next para. First, comma, the devolution of title in respect of the suit property from Jyotindra Mohan Ghosh through Avani Mohan Ghosh to the present parties has not been substantially denied by the defendants to respondents. Pushed up. Secondly, comma, the respective heirship of the parties and the line of succession as pleaded in the plaint has also not been categorically denied in the written statements. Pushed up. Next para. Since the premise of the plaint pleadings is that the property was devolved upon the present parties by way of inheritance through several generations, and the plaintiff was able to produce tax receipts to prima facie show that they are in possession and that there is a presumption of ownership, comma, we find it rather peculiar that the learned trial judge dismissed the suit instead of decreeing the same in preliminary form. Full stop. Also, comma, although the defendants respondents have uh, paid lip service to denial by denying on paper the share of the plaintiff, comma, since the line of succession and the heirship of the parties have been admitted, comma, there is no scope for deviating from the shares as laid out in the plaint pleadings. Full stop. Next para. Thus, comma, we are of the opinion that the appeal itself can be disposed of along with the application. Full stop. In view of the short conspectus of the appeal, comma, we are not inclined to call for the records at this juncture. Full stop. In view of appearance through learned advocate, comma, service of notice of the application and the appeal on the respondent number 4 is dispensed with.
Free, my lord, free. On you.
যেখানে যেখানে 4 বলেছি 3 হবে। Fee is dispensed with. Full stop. Next para. The petitioner shall serve copies of the application and the memorandum of appeal on the remaining respondents, indicating that the appeal and the application shall be listed for hearing on January 14, 2025, when the appellant shall file an affidavit of service. Full stop. The service by registered post as indicated above shall be deemed to be good service in respect of notice of the appeal as well. Full stop. However, comma, for the sake of convenience, comma, the appellants shall prepare and file the requisite number of paper books incorporating the necessary documents. Informal bolam to. Informal paper incorporate necessary documents without comparing with the records before the next returnable date, and serve advance copies of the same on the respondents, comma, directly or through their learned advocates. There shall be stay. There is no scope of stay. What is the application for injunction? Very well. The parties shall maintain status quo with regard to the suit property till disposal of the application.
My lord,
Blanket status quo.
my lord, let's the my lord LCR come, my lord, because my lord the exhibits, my lord, your lordship kindly looks at the exhibits.
But even without the exhibits, my lord, with an admission, my lord, I'm entitled to a degree. Let my learned friend
for the-
substantially say that what is the
For the time being, we are not. If you can, Mr. Mukherjee, if you can do that, then it will be better if you can take out certified copies or whatever of the exhibits and make those a part of the paper.
I'll try to do that.
And you'll serve advance copies of the paper book. সেটা বলেছি কি? বলেছি। You serve advance, হ্যাঁ, বলেছি। Serve advance copies so that you can also check up. You also try to find out the exhibits.
Certainly.
Plain written statement, evidence exhibit, and the rest is already here.
Only one exhibit, my lord, is valid, my lord. The contact.
Tax receipt, but let them find whatever they. The Aadhaar cards are very important nowadays. We have to ascertain your identity first. Thank you.
নিজেদের মধ্যে করেও না তাহলে তো অন্য কারোর উপর পায়নি
Sorry, yes.
Lordship, on behalf of the respondent number 1 to 4, Lordship, I am being led by Advocate Abhishek Prasad. Lordship, due to his mother's illness, he could not come to court today. I am praying for not this week, Lordship.
What is the application for?
Against an order whereby my application for injunction was refused. It was a suit for partition, my lord, wherein
Injunction refused. Why have you asked for stay of operation? This application is for stay. What will stay fetch you?
even
Your injunction has been dismissed.
Has
So we'll stay the operation and the injunction will revive. The application will revive. But the application is still there. I didn't tell you as well.
even if an order of status quo is passed by this court.
You are not praying for injunction in your application. Where are the averments regarding injunction? There is no scope for stay. Yes, para 11 you have asked. Mr. Jha, we should not advise you, but you just consider.
I'll take steps.
Consider because you have to make averments regarding the cause of action for injunction. Only para 11 you say restrain them. But you have not said that they are trying to do anything. So we can permit you to use a supplementary affidavit. They get that 1 week also in the meantime. You serve them a copy with it.
Let me file the affidavit of service and one supplementary affidavit where the application for injunction. I have
Mr. Bhatt, keep it with you. Was there any previous leave? Leave granted to file supplementary affidavit? File a composite supplementary, one supplementary affidavit incorporating these things also, these pleadings also. So how soon can you do that?
1 week after vacation, my lord.
Very good. At the time of hearing the application, comma, it transpires that the application prays for stay of operation of the impugned order, which is an order of refusal of ad interim injunction. As such, comma, stay would not serve any necessary purpose for either party. However, comma, there are rudiments of prayers for injunction in the application as well, comma, without the corresponding necessary averments. Hence, on the prayer of learned counsel for the appellant stroke petitioner, comma, the appellant stroke petitioner is granted leave to file a supplementary affidavit incorporating necessary averments and annexing documents, comma, if necessary. Next para, such supplementary affidavit shall be affirmed within January 10, 2025 and shall be filed on the next returnable date. Affidavit in the respondent shall file a composite affidavit in opposition in respect of both the injunction, both the application as well as the supplementary affidavit within January 24, 2025. The application shall be listed for hearing on January 27, 2025. The parties shall maintain status quo with regard to the suit property in the meantime.
Right. Lordship, keep the affidavit of service on record, my lord.
Affidavit of service filed today be kept on record.
Obliged.
Matter for the appellant. But my inadvertent mistake on part of the advocate on record, it has been filed. It has to be filed before the chief judge, city civil court, because it's a decree passed for eviction, in by the small causes court, It has.
So we'll give you liberty to take back the certified copies.
Yes.
Learned counsel for the appellant, comma, in his usual fairness, in his unusual fairness. In his usual fairness, submits that the appeal has been wrongly preferred before this court due to bona fide inadvertence, and that the appropriate court having jurisdiction is the city civil court at Calcutta. Next para, we find corroboration of such submission from the materials on record and the impugned judgment. Accordingly, FA T 321 of we have not checked the judgment actually. It's yes. Accordingly, FAT 321 of 2024 along with CAN 1 of 2024 are dismissed as withdrawn on the prayer of the appellant, comma, granting liberty to the appellant to take back the certified copies of the impugned judgment and decree upon furnishing duly authenticated photocopies of the same for the records. Liberty is also granted to the appellant, comma, irrespective of the present dismissal, comma, to prefer an appeal before the appropriate court having jurisdiction on the self-same grounds. Full stop, no order is to
Left, my lord, left.
Not written within a productive day. Yes.
But item number 15 my lord, on the last occasion.
না ফর্মালি তো আমাদের জানাই না মেন বিল্ডিং এ উঠতে জানানো হয়ে গেছে অফিস বের সরি মিস্টার সেন ইয়েস
My lord, item number 15 my lord, on the last occasion, my lord had passed an order, my lord, whether we can get the address of the respondents, my lord. The relationship has between the parties have gone so worse, my lord, we could not recollect the collect the addresses, my lord.
recollect or collect
Collect, my lord. So far as the respondents number
this is against a preliminary degree of partition or dismissal of partition final degree
Alright, so far as respondent numbers 1, 2, and 3, my lord, we will serve, my lord. Furthermore, we will put in requisites also. They are not available at the address given, my lord.
1 2 and
3.
oh the
For the
substitute
others, my lord, 4, 5, and 6, my lord, we will only serve by registered post, my lord, by speed post.
and 1 2 and 3
1, 2, and 3 by speed post, and also, my lord, we need to put in requisites, my lord, because it will come back
we cannot do it piecemeal then you have to put in requisites for all
we'll put in for all.
put in for all
Then
because that
only by requisites we'll
do that
Right.
we will issue a rule
But rule, my lord,
requisites for what the application is pending
postal cost, we'll put in postal cost rather. For service by the department, my lord. Rule, my lord, it will get delayed, my lord.
service to the department can only be by a rule
Generally, we put in postal cost also, my lord.
for the appeal yes for the appeal notice
The
notice of appeal by postal
Well,
cost you
then
put in postal
rule
cost
rule we
but in application there is no such provision
Well, the application or rule is generally issued, my lord. That is the prayer, my lord.
no yes that is there but otherwise also appeal notice of appeal only postal cost you put in and the notice goes but service of the applications is not done
There are 3 applications, one under 146, section 146, and the other is A, my lord, and the other is section 5. my lord.
to serve all the application section 5 has to be served oh, then you cannot pass any interim order
No, they do it at this stage, my lord.
can 1 2 and 3 what are the cans
Can't 1, 2, and 3.
very good সবকটা অ্যাপ্লিকেশন ইয়েতে দেখিয়ে দিই but if you don't know the current addresses this is the first time you are directing service
My lord. But let the others appear, they know, my lord. I am told,
no
my lord.
Mr. Shen issuing a rule would not help you because the same fate will be then
But,
serve on them will direct you to serve
Right.
in the meantime ascertain we are not recording anything that they are not residing there
Right.
there is nothing on record to show that they are not residing
Except the order, my lord, the earlier order passed by your lordship that where, my lord, the current address is
acha
ascertained, my lord. That is there.
your fairness cannot be your nemesis we'll try to catch up in the order dated December 11 2024 it was recorded as per submission of learned counsel for the appellants that address of some of the respondents might have altered in the meantime full stop however comma in the meantime comma the appellants could not ascertain any change of address full stop accordingly there cannot be any impediment comma for the present comma to send copies of the applications to the addresses of the respondents as reflected in the cause title of the memorandum of the and the applications comma which is also their addresses as found from the trial court's degree same address from the trial court's degree full stop the present appeal has been preferred against a final degree of partition full stop next para the petitioners shall serve copies of all the 3 applications on the respondents indicating that the applications shall be listed for hearing on January 20 2025 when an affidavit of service to that effect shall be filed by the petitioners full stop affidavit in opposition comma if any shall be filed by January 10 2025 full stop reply if any shall be filed on the next returnable date. For the time being, let these directions be there. In the meantime, if you can get the addresses,
Fine.
probably you cannot because the relationship is sour.
But let me, so far as the some of the respondents, they will appear, my lord, if they intimate to the plaintiff respondents, then my lord, the impasse may be over, my lord.
No, if they were represented by counsel in the court, you can speak through counsel, even if the parties don't talk among themselves.
But that I can serve upon the council also without an order, my lord. I will try to get.
No, ask them. Ask them.
Fine.
You or ask your counterpart in the court below to ask them.
Fine.
That much bonhomie should be there.
Great.
Yes.
Milord, I am for the Milord.
This appeal was admitted, FMT?
Milord, it is a delay of 19 days, Milord.
19?
19 days. Milord.
19 days?
Only 9.
You have given copy?
Yes, yes, I have served to the caveator. Some Sajnach.
An application was not served, your
Yes, Milord, I served everything. Milord.
Affidavit of service you have filed. Where is the affidavit of service? If you have served, there must be some affidavit of service.
You have served.
You have never heard of affidavit of service?
Yes, Milord.
So then why are you looking like that at us?
Milord,
Where is the affidavit of service? You have served, give us this affidavit of service.
Milord, I have to.
Give a copy. Your money is saved. You don't have to send by post. Your friend is
I am
here like an
giving
angel
it
to help.
him to today, Milord.
Please give your details. He'll give it to you. What is your name, please?
Advocate Sandeep Dinda, your lordship.
Mr. Sandeep Dinda appears and submits that he has instruction to appear for the respondent and seeks copies of the applications. Full stop. Next para. Accordingly, the learned advocate for the appellant shall serve copies of Can 1 of 2024 and Can 2 of 2024 on Mr. Dinda today.
Yes, Milord.
During the course of the day and file a receipt in that regard on the next returnable date. Full stop. Next para. The application shall be listed. Applications shall be listed for hearing on December 23, 2024. We'll put it on Monday. Let all the applications come up. We'll probably allow the section 5 and take up this thing.
Phone number.
But ensure that it is served today, please.
Yes.
And you have to file a receipt on the next date.
Yes.
If they are not present, we want to be ascertained that.
I am for the appellant, my lord.
Yes, please.
My lord, this is under admission stage, my lord.
Admission stage.
My lord, first time appearing, my lord.
City Court.
No, my lord.
Malda.
Malda, my lord. Order of
Admission. There is no section 5.
No, no, sir.
So then we don't have determination because we have determination to take up order for turn matters only after 2020, only up to 2020.
That's the first appeal, FMT.
First miscellaneous appeal. First miscellaneous appeal we have 2016 onwards. But if it's at the order for turn stage, only after 2020. So you have to get it admitted before Justice Tandon and immediately thereafter you have to come before us and mention. That is the determination. We can't help it. Let the matter stand released from our list due to lack of determination to take up order for turn matters after the year 2020. Full stop. Liberty is granted to the appellant to mention for enlistment before the appropriate bench having determination. Get it admitted there formally and then come before us. None appears for the parties. Let the matter stand adjourned for the day. Same. 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 Same order. Same. Same order. You are for the appellant.
I am for the appellant. I have also filed an application, my lord.
What is the application for?
There is, my lord, it is a case for declaration.
Please come a
Yes,
bit
my
closer
lord.
to the one. Yes.
There's a case for when the declaration that the share, which was actually in the name of the appellant, plaintiff therein, has been lost by.
Is the mic functioning or are you too soft spoken?
And sometimes, my lord, my voice increased so much that
No
I have to
difficulty, but
control.
Take the microphone a bit closer. We'll be able to.
Am I audible right now?
Yes, absolutely. Yes.
This is the matter suit for declaration
right?
that for but the shares.
Paper books
Paper books has been completed.
গুলো দিন।
But therefore, madam, there are some discrepancies in the paper book. All the exhibits are not included in the
You
paper
have
book.
prepared the paper books.
I have prepared the paper.
So you have to file supplementary.
Supplementary. I have gone through because all papers, my lord.
Shall I
because
then we'll direct her to file supplementary affidavit.
Last occasion, my lord, your what fallen from your lordship's, my lord, that it is a share, my lord. The share has been transferred to different plaintiff number, the appellant herein, because it was in the name, because the previous company, the name of the company has been changed.
Mr. Lyre, you are appearing for the company.
No, I'm appearing
The
for
shareholders, the contesting shareholders.
the holders of these shares, Miller,
All right.
purchased in the open market.
All right.
I'm for the respondent number 5 and the heirs of respondent number 5 in the
All right.
memorandum of appeal.
All right. You are for 6 years. 4. Very good.
The appellant has purchased the
You have
share.
served on the Tata Iron and Steel Company as well.
Not contested in the trial court as well.
Very good.
And my entire complaint and entire allegation on the 1 and 2, because they have misappropriated my shares.
No, misappropriate. They are the company of which the shares you are holding. I mean, you are claiming.
That has been lost.
Say you are
the
the.
physical share that has been transferred. It was supposed to, the physical copy has to be.
You say you are the owners of the shares.
Yes.
What is the plaintiff case? Let us hear that.
The plain case is that the plaintiff in the previously it was name of the Gaylord Industrials. It was is the owner of 2290 equity shares.
Right.
Then the name of the company has been changed and become the company has been merged and the appellate become the owner of that 2299 share. They have made application for change of name of the shares, and then, my lord, the share has been lost in the means, my lord, in transit. Now after that, they have made inquiries to the respondent number 2, but they in the year 1995 they sent a letter that for 1550 of share has been transferred to various other persons who are now included as defendant number 2, 3, 4, 5, and 6. Now, when the order has been passed, the impugned decree has been passed, where it has been recorded that my entire case was for 2220 of shares, number of shares, that the suit property, the dispute regarding only 1550 of the shares, and remaining 770 shares is actually in minor. That is the record in the.
In this
yes.
matter, that question arose that the particulars of those shares
Yes,
are not.
but particulars is in the plaint itself, though it's not in the schedule, which is supposed to be like in a
Plaint
schedule.
itself is not that is not the particulars of the shares.
The numbers and dividends, distinctive numbers has been given.
Oh, achha, everything has been.
Yes, yes. It is
The
in
details of
two.
each of the shares.
Each of the shares. Paragraph 2, it's page 21 of the
এই পেপার বুক গুলো দিন। আগের দিন তো ছিল পেপার বুক, আবার কোথায় গেল?
Anyways,
You served or the department served?
served them, and the affidavit of service.
Ms. Mukhopadhyay, you prepared your supplementary paper book?
Yes, and I will give all the
interchange and then
yes,
come back.
yes.
Instead of piecemeal hearing,
Yes,
this will take us nowhere.
Yes, yes.
Learned counsel appearing for the appellant, in her usual fairness, submits that some of the documents, some of the relevant documents are missing from the paper books which have already been filed. Pushed up. Learned counsel appearing for the respondent number 4 submits that the said respondent has not received any copy of the paper books. Pushed up. Next para. In view of the prayers, in view of such submissions, the appellant is directed to file supplementary paper books incorporating all the omitted relevant documents pertaining to the LIS, pushed up. Next para. Advance copies of the supplementary paper book shall be served on all the respondents. Pushed up. A copy of the appellant shall also ensure that a copy of the original paper book is served on the respondent number 4th through Counsel. First up, the appeal along with the applications shall next be listed for hearing in the monthly list of January 2025. Let it be in the monthly list. If you can do it within that, then we'll take up the appeal. Mr. Lahiri, you have got the paper books. The others, you both of you have.
Incomplete paper book I have got.
I have served.
Acha, একটা line act add করে learned counsel for the respondent of 4 submits that the said respondent has not got any paper book. ওই sentence act add করে দিন.
We have filed in the department. They have to take it from the department.
It also appears that complete copies of the paper books have not reached reached any of the other respondents as well. First up, আর পরে যেখানে বললাম serve a copy of the shall ensure last sentence shall ensure that complete copy আচ্ছা ওইখানটা করে দিন complete copies of the original paper book are also served on all the other respondents in the meantime.
The copies are already.
You said we asked you. You said that
No, my lord,
we asked you whether you served or the department served. You serve. Mr. Lahiri will pay for all the papers. All the Mr. Lahiri will pay from his pocket for the photocopies of all the papers. Yes. You're too rich for not paying.
Not
Madam,
too rich,
please
my lord.
use the
I'm
standard
just a
standard
more
copy.
shareholder.
No, not your client. You will pay.
But I can pay for my copy.
Photocopies. No, we have not recorded that in our order.
It may be granted to withdraw, my lord, though, which is we have already deposited in the department, the paper books.
No, that will create complications.
Instead of the monthly.
You can file it in court on the next date, serve advance copies to them. No, but you have already prepared paper books. Acha, where we will grant you that. Acha, after line add kore dao. It is made clear that it is the appellant who will now serve copies of the original as well as the supplementary paper books on the respondent's counsel. Full stop. For such purpose, the paper books already filed in the department shall be returned to the learned advocate on record for the appellant. আচ্ছা পেপার বুকস কি এখানে আছে? হ্যাঁ থাকবে তো বটে এখানে তো থাকবে বটে থাকবে না কেন? আচ্ছা একটা লাইন অ্যাড করে দিন the records be sent down to the department for compliance of the above directions. সব যা রেকর্ড আছে পেপার বুক সব পাঠিয়ে দেবেন দেখে নেবেন পরে পেপার বুক থাকবে এখানে এই রেকর্ডস আজকেই পাঠিয়ে দেবেন Thank you.
Any date for the supplementary paper book? Any date?
We have not given any date. We have kept it fluid. Mr. Lahiri, we have kept the appeal and the applications in January monthly list. Before that, she has to do it.
The monthly list could it be in the daily list? Any days?
No, we are not sure when the paper books will be served, Mr. Lahiri. That's why.
Let be in the monthly.
Not many appeals are heard. Whatever appeals are heard, only 2-minute, 3-minute appeals mostly. You stay in court and Mr. Lahiri will find out most of the appeals have nothing in there. So we are taking up appeals, more or less disposing of some appeals.
Expected my learned friend will file it before that.
I will try.
She also expects.
No further adjournment is sought for because of intervening vacation.
Try not to take any action.
Okay.
Next.
Is it parted?
No, definitely not.
Not hard in part.
No. If it was parted, we would have cancelled. Next, 26. 26 is appearing.
The respondent number 1 PMC, my lord. I'm led by Mr. Aurik Banerjee, my lord.
Mr.
Aurik Banerjee, lord.
Mr. Aurik Banerjee.
He's leading me in this matter.
You are Miss Sengupta?
Yes,
right.
lordship.
Yes, Mr. Sen, what is that?
Yesterday, I submitted that the point which is.
Mr. Sen, can you take the microphone a bit closer to you? Any of the microphone?
The suit was filed.
Ms. Sengupta, take your seat.
Suit was filed. The defendant number 5 is the appellant who purchased a stranger purchaser the flat of one co-sharer. From the defendant number 1 to 4.
Oh, this is that prior purchase clause. You're challenging.
No selling without offering. No, like section 4, but section not.
So incorporated in the deed.
Yes.
Yes.
I submitted that this clause is invalid.
Whether this is valid.
Well, the plaintiff, that one of the co-sharers.
You filed a suit for partition.
Plaintiff suit for not for
Oh,
partition.
you are a defendant.
For
One of the
declare-
co-sharers filed the suit.
One of the co-sharers filed the suit
Very well.
for declaration that he is entitled to exercise the power of preemption in terms of that clause contained in the inserted in the partition deed
Oh, the suit was for preemption.
to exercise preemption. Yes, for preemption, and also for my lord declaring the deed, my lord, whereby the property was sold to me is invalid and illegal, and also mandatory injunction and part. The suit was decreed.
So, Mr. Shen, we
Contest
have to
against me.
look into two deeds basically: the partition deed which they rely on, and your transfer deed.
Mainly partition deed containing the.
Yes, exactly. Your transfer is not disputed.
Yes, it is not disputed.
Otherwise, not disputed.
Because they have said that. Yes,
They are challenging that.
they're telling me that. Well, the suit was decreed against the defendant number 1 to 4, my lord, ex parte. They did not contest. Naturally, they have sold. They have
Yes.
washed their hands.
They are selling with you. Yes.
Then, my lord, and on contest against me. Now.
Oh, apart from this plaintiff, all the other all the other
Other co-sharers are not made party. Only the defendants co-sharer from whom I purchased.
Very well.
I was employed defendant number 5.
Mr. Shen will resume in 5 minutes.
My lord.
এই পেপার বুক গুলো হ্যাঁ এই পেপার বুক গুলো দিন। Should you come to the judgment or
May I first, my lord, place the condition, then I will go to the judgment.
whatever way?
Particular clause is lost in the partition is 15 February.
হ্যাঁ দিন দিন, এটা দিতে হবে। Page 182.
This is, my lord,
Clause is at 191, Lordship.
191. 191.
Yes, it starts at
First 10.
191, yes.
That none of the parties shall be entitled to sell or transfer his allotment to a stranger without offering the same to the
One minute,
other
give us
party.
half a minute. 1 minute. Shall be entitled to sell or transfer
His allotment to a stranger without offering the same to the other parties, and will be bound to sell and transfer the same to any of the parties who will offer the highest market value prevailing at that time. In case the other party refuses to accept the same, then only the intending party will be able to sell or transfer his allotment in favor of the stranger, in favor of a stranger. So this is the, my lord, restrictive clause in the partition deed.
Is it stated anywhere that it's a dwelling house, family dwelling house in this deed?
It is not a family doing. It is, my lord, I tell you, lordship, then, my lord, I must place in the first hand the plaint case. Plaint, just a few paragraph I will place with your lordship. Page 3, paragraph 2. Lord. Plaint, paragraph 2 of the plaint at page 3 of the plaint paper book.
Yes.
1. Viraj Lakshmi Devi, deceased, wife of late so-and-so, since deceased, who was the mother of the plaintiff and grandmother of the defendant number 1 to 4, purchased a plot of land measuring 2 gutters, 5 acres and 28 square feet from Calcutta by deed of conveyance registered so-and-so. Then, my lord, the said Viraj Lakshmi Devi, next page 4, made a published her last will and testament on 14th day of July 1959, whereby she bequeathed the said premises in favor of 5 sons, 1, 2, 3, 4. Gopal number 4, Gopal Chandra Bhattacharya was the plaintiff. The plaintiff herein, and Narayan Chandra Bhattacharya in equal shares. The probate of the said will, next paragraph, and granted by City Civil Court on 15 December 1988 in probate case number so-and-so, by virtue of which the aforesaid 5 sons, including the plaintiff, jointly became the absolute owner of the said premises, each having undivided 1/5 share. So, my lord, just we are to keep in mind, pausing here for a moment, that this is a, my lord, testamentary succession. Then, my lord, by virtue of the deeds,
Para 5.
Para 5. The virtue of the deed of partition dated so-and-so, the plaintiff became the absolute owner of the flat number, first floor, back portion or premise number 1770 Vivekananda Road. And the flat number, flat on the 3rd floor at premise number 177C Vivekananda Road, Calcutta. And the different number 1 to 4 became the absolute owner of the flat number 177C Vivekananda Road, 5th floor, and one flat 177D Vivekananda Road on the 3rd floor, back portion, and one shop room on the ground floor in premises number 177B Vivekananda Road, Calcutta. And also window shop room on Vivekananda Road in between 177A and 177B Vivekananda Road, Calcutta 26. Well, it came from the evidence that the mother of the plaintiff and the grandmother of the defendant number 1 to 4 she constructed the building.
Mr. Shen, is the first premises number correct? Premises number 1770 or it should be 177 something?
It should be
Because the
170
others are 177.
177.
What is wrong? Zero is wrong.
Actually, flat numbers. Yes, zero is wrong.
So that should be premises number 177.
177.
Mother premises.
177.
Because obviously, otherwise.
Others are shops, all are 177.
Yes. Yes.
Yes. Then, my lord, paragraph 6.
Yes.
Pursuant to clause 10 of the said deed, partition deed, dated so and so, such allotee or set of allotees covenanted not to sell his or her divided demarcated share to any outsider without offering first to other allotees. The defendant number 1 for self and on behalf of the defendant number 2 to 4 served a letter dated 10th January 1999, which was posted on 16th February 1999, whereby defendant number 1 for self and on behalf of the other without disclosing the proper identity as to on whose behalf the said letter was addressed, asked the plaintiff whether he is agreeable to purchase the said flat more fully described in the schedule in underwritten, and he have referred to the suit premises at or for a price of 5 lakhs. So notice was given to them. I skip. The next paragraph 8. Immediately after receipt of the said letter, defendant number 1 on 2nd February, the plaintiff intimated the defendant number 1 and others that the plaintiff agreeable to purchase the said flat at a price of rupees 5 lakhs. And the plaintiff inquired some particulars as contained in the letter dated 25th February 1999. Now, my lord, considering the points involved, we may not go further.
We are going to say that because this is not
We may not.
necessary.
Yes.
Whatever we had to see, I've seen, it has not been averred specifically, it was a family dwelling. Anyway, let us.
Flats.
The rest, the
individual
cause of
individual
action.
Flats. On the ground floor, shop room, window shop room is so and so. So it is not a dwelling house like in our Paraguay that wood home is there, then a lot of houses are there. Then, my lord, prayer, you may straight away go to the prayer.
Yes.
Page 13. Page 13.
Right.
Decree for declaration that the plaintiff is entitled to exercise the right of preemption over the suit premises in terms of the deed of partition dated 13/12/1989. Decree for declaration that the sale deed of the suit premises by defendant number 1 to 4 in favor of the defendant number 5 is illegal, invalid, and in breach of the obligation contained in the deed of partition contained.
We have seen, Mr. Shen, so basically declaration of the preemption right, cancellation of your sale deed, and mandated injunction
to give the
yes, in their favor. What was it?
No, the written statement I have dealt to it.
Only you filed written statement.
Only others, my lord, my vendor did not contest.
No, very good.
I will, my lord, refer to paragraph 8, 7 of my written statement at page 25 of the paper book.
Yes.
That with reference to the statement made in paragraph 6 of the plaint, this defendant denies and dispute each regulation made therein. This defendant states that clause 10 of the partition deed cannot be enforced or made applicable as soon as the property in question is divided by metes and bounds and separate allotments have been made to the respective parties. Then, my lord, paragraph 14. Paragraph 14. In the same tune, with reference to the statement made in with reference to the statements made in contained in paragraph 13 of the plaint, the defendant stated that clause 10 of the deed of partition dated so and so cannot be enforced in view of the fact that after partition is effected between the co-sharer and separate allotment has been made to the respective co-sharer, the right of preemption lost its force and as such it cannot be enforced. 7 of said this defendant deny and dispute each and every allegation contained therein.
Due to Partition Act. Yes, Mr. Shen.
While it's going to partition section 4.
Section 4. No other section.
Two conditions. The stranger has to file the suit. Undivided remains undivided, then stranger.
So, but then Section 4 confers a power even after the transfer.
Yes, even
But
after
the
transfer.
precondition is it has to be an undivided family.
Undivided
So
family.
you say that once the co-sharership is severed by this partition deed, then joint ownership does not survive. So after that, there cannot be a post facto clause restricting, because then each become
Absolute owner
absolute
of the
owners of each
respective
of them.
shares and
Very
all.
well. Very well.
My lord.
Very well.
And also, my lord, Section 4, the other co-sharer may take recourse of Section 4 by filing an application that the property sold by one co-sharer should be sold to me after assessing the value by appropriate authority.
Then they
So
can-
there should be a suit to be filed by the stranger purchaser for his separate possession and partition. There must be a suit, but here is not that case. But the restriction clause somehow, my lord, is similar to Section 4. Somehow similar. However,
No, but Section 4, why isn't it not applicable? Why couldn't he file today a suit under Section 4? Where a share of a dwelling house belonging to a has been transferred.
Yes.
Oh, sorry. You're right.
such
It does not
transfer
remain.
is used for partition.
Does not remain an undivided house. Section 4 is
At
not.
that stage, partition suit undivided. But
Yes,
here
yes.
it is divided.
After partition by me, they admit partition deed. So after that, it becomes divided. Very
Yes. My lord, then my lord, paragraph 15, same stand in the same tune, page 30 of the paper book.
We'll hear you on your arguments. On
Yes, my
that.
lord.
So you have taken the stand and
So I have
in the
taken
clause.
this point. I have taken not that
Categorically
this is
taken
for the first time I am taking the new.
No, no. You have
That is
taken
why
the
I was searching for that.
So we can, we suppose we can go to the judgment.
Yes, yes, yes.
Impute judgment.
My lord, and another thing.
Yes.
My lord, assuming that your lordships may not agree with my or may not accept my submission.
Yes.
In that case, my additional submission or point of law to be submitted is that the plaintiff failed to establish his case, even regarding sending notice, giving reply thereto. That because the different number 1 to 4.
So you said the cause of action was not established.
No, not at that. But I say that
what was not established?
Constituted attorney cannot depose, cannot give evidence. Now it is.
What case did he have to prove? He's an admitted co-sharer. You are not saying that he was not a co-sharer.
Well, the law now, latest judgments in 2024 judgment Supreme Court and also my lord of our court is that the constituted attorney cannot depose or cannot give evidence.
Law
They
was
can
that.
accept.
Law was that from 100 years.
Yes.
Constituted attorney cannot depose as a constituted attorney unless he has
personal
direct knowledge.
Direct knowledge.
And if somebody has direct knowledge, he need not be an attorney at all. He can come and depose. Anybody having
Yes,
direct
yes,
knowledge can depose.
But consider as a constituted attorney.
Constituted attorney cannot. But if suppose there was no evidence, you admit their co-sharership. So what did they have to prove? Everything is on record.
Regarding sending notice and by the different number 1 to 4.
Sending notice?
To the by the different number 1 to 4, giving offer to the plaintiff. And my lord, which I have stated in evidence that I have no knowledge. I had no knowledge, I have no knowledge. And my lord, reply by the plaintiff to accepting the offer. These parts as came by evidence from the constituted attorney cannot be accepted as evidence.
All right.
If that be so, then the plaintiff failed to establish that part.
All right.
Failed to establish that part. Even those are on record evidence, but it cannot be accepted as evidence.
But can't he ask for a purchase on the strength of the clause itself, even if there was no offer acceptance? Because the clause 10 of the partition deed says that they has to be. They have to put up for. They have to give a prior offer.
My lord, it is a my lord contract.
Let us
Partition
proceed.
contract.
Very well. Yes.
It is a contract. Then my lord.
So then also, if they have not done that, if the defendants have not given that offer, then also he can enforce clause 10 if he otherwise is entitled to. He says, goes one step further, he says an offer was given, I accepted, still sold.
It is there, evidence from there, from the side of the plaintiff.
But suppose
I have
that-
no knowledge.
But suppose we disbelieve that even.
Yes.
We don't take the evidence on that.
Yes.
Then what remains is that no offer was given by the defendants to him, and he did not accept.
Yes.
Even then the clause remains. Even if we proceed on that premise that no offer was given at all and sold to you directly, even then, I mean, that, although that's a secondary point. Very good.
Yes, a secondary point.
The
Now,
first
my lord,
point remains. Yes, first point remains.
First point remains. Now the judgment says that once by way of partition or by sale, transfer, even by, in a case, I'll show you lordship with the Delhi High Court case, even by, my lord, bequest by will, once the intention of the propounder is that to give absolute ownership, subsequent clause is invalid. Subsequent clause, restrictive clause is invalid. Delhi High Court also. That is in case, even in case of, my lord, bequest by will.
All right.
Even in equally, my lord, in case of transfer, you cannot put condition. Far less to speak, subsequent restrictive clause. Far less to speak, cannot. Then, in a case of partition, even when the partition has been made amongst the co-sharers, then by virtue of the partition, all the co-sharers became the absolute owner of their respective allotted.
That cannot be curtailed by a previous.
That cannot be curtailed. Then, my lord, if I became the absolute owner of the property, of my property, then that restrictive clause, in my humble submission.
Not you, actually, your vendor.
Yes.
Your vendor became the absolute owner. Yes. Once became absolute owner by virtue of the same partition deed, further restrictions, fetters cannot be put on that absolute owner.
Yes. So that,
if that cannot be put, he can do whatever he like.
Yes. Only thing that I have to show by judgment that it cannot be done. If that is invalid,
let us see the impugned judgment and cite your judgment.
Yes,
it will be over and done away with.
Yes. Now, judgment is at page, starts from 88.
88.
Yes.
Ms. Sengupta, why are you standing, jumping up occasionally? You want to say something?
Assisting with the page number.
Page number.
Take your seat. Yes.
Yes. Starts from 88, man.
Yes.
Page 2 of the inner page 2, 89.
Yes.
This is for enforcement of right of preemption and injunction. Plaintiff case in this is that different number 1 to 4 of the daughters of his elder brother, Biraj Lakshmi Devi, since deceased, wife of late Parinath Bhattacharya and mother of plaintiff and grandmother of the different number 1 to purchased the plot of land from the CIP by registered deed of conveyance dated so and constructed a 6-story house.
Hindu Succession Act on in.
Hindu Succession Act.
Please continue. Yes.
We have brought, my lord, which was numbered as 177 and 177 on the road, Kolkata 6. She executed a will on 14/7/59 in favor of her 5 sons, late Madhusudan Bhattacharya, late Dinabandhu Bhattacharya, late Nilmani Bhattacharya, Narayan Chandra Bhattacharya, and the present plaintiff, and bequeathed the said premises in their favor in equal shares. They got the probate of the will on 15/12/1988 and became the absolute owner, having 1/5 undivided share each. Late Dinabandhu Bhattacharya was the father of the different number 1 to 4. Further case of the plaintiff is that by virtue of a deed of partition dated 13/12/1989, the plaintiff became the absolute owner of the flat on the first floor back portion of premises number 177 and the flat number flat on the third floor front portion at premises number 177C, and the different number 1 to 4 became absolute owner of the flat number 177C on the fifth floor and the flat number 177D on the third floor back portion and one shop room in the ground floor in the premises number 177B. We were on the road, so and so, and also window shop room in between 177A, 177. Therefore, there were 2 towers or 2 buildings. it appears. In pursuance to clause 10 of the said deed of partition dated so and so, 13/12/89, such allotee or set of allotee were covenanted not to sell her divided and demarcated share to any outsider without offering first to the other allotee. The defendant number 1 on behalf of the self and the defendant number 2 to 4 served a letter dated 10/1/1999, which was posted on 16/2/1999, asking the plaintiff whether he was agreeable to purchase the said flat described in the schedule of the plaintiff for rupees 5 lakhs and sought for reply within 30 days. Receiving the letter on 22/2/1999, the plaintiff intimated the defendant that he was willing to purchase the said flat for rupees 5 lakhs and inquired for some particulars. In the said letter dated 10/1/1999, the defendant number 1 did not disclose her proper identity and address for communication. She received the letter of plaintiff on 1/3/1999, but did not respond. The plaintiff was under impression that she will inform the plaintiff as to queries to enable him to purchase the said flat. On or about 10/3/2000, the defendant number 5, who is residing in the said flat, so I am residing in the said flat. It is admitted question, met with the plaintiff and requested him to pay the arrears of corporation tax of the building. When the plaintiff asked him about his status, he did not give any satisfactory reply. Thereafter, the plaintiff caused inquiry on 11/3/2000 in the office of the Registrar of Assurance, Kolkata, on 16/3/2000, be obtained the certified copy of the impugned register deed of conveyance dated 15/2/1999, and came to know that the defendants have fraudulently concealed the factum of sale of the suit flat for a consideration of 2,50,000 to the defendant number 5, being fully aware of the covenant of clause 10 of the said deed of partition dated 13/12/1999. The defendant, in collusion with each other, and served the offer letter making a false statement that consideration was rupees 5 lakhs. And they also made a wrong schedule of impugned deed mentioning about 1 veranda, but in the sketch plan 2 verandas are shown. There is an active concealment of the impugned sale transactions with intention to deceive the plaintiff and to deprive him of the legitimate claim. He has right of preemption, preferential right of purchase in terms of the deed of partition dated 13/12/1999, and also under section 22 of the Hindu Succession Act 1956. Plaintiff issued lawyers' notice dated 25/3/2000 upon the defendants, asking them to cancel the impugned deed of sale and to sell the suit premises to plaintiff, but to no good. Hence the suit. The defendant number 1 to 4 and 6 did not appear or the contest the suit. Hence the suit was heard ex parte against them. The defendant number 5 contested the suit by filing written statement challenging the maintainability of the suit and denying the material element in the plaint. He contended inter alia that clause 10 of the partition deed cannot be enforced or made applicable as soon as the property in question was divided by metes and bounds, and separate allotment have been made to the respective parties. The defendant had no knowledge about the letter dated 10/1/1999, which was posted on 16/2/1999, whereby the defendant number 1 for self and on behalf of the defendant number 2 to 4 asked the plaintiff as to whether he was agreeable to purchase the suit flat for rupees 5 lakhs. Also, he has no personal knowledge as to whether the plaintiff was willing to purchase the said at the price of rupees 5 lakhs, and whether intimated the same to the defendant by letter dated 22/1999. Further, he had no knowledge as to whether the plaintiff was willing to purchase at the price of rupees 5 lakhs, and whether he intimated the same to the defendant by letter dated 22/1999. Further, he had no knowledge as to whether the defendant number 1 in her letter did not disclose her proper identity or address. The defendant did not meet with the plaintiff on or about 10/3/2000, nor did he request him to pay the arrears of the tax as alleged. Defendant further contended that he purchased the suit flat from the defendant number 1 to 4 after partition was effected by metes and bounds amongst the co-sharer, and separate holding number was allotted to each of the flat owners. Although the said sale price in the deed is mentioned as 2,50,000, but he had to pay additional stamp for valuation of the said flat which was assessed by the Register of Assurance, Kolkata, at rupees 6.2 lakhs, 20 lakhs, and he has got money receipt issued by the said register. The plaintiff is not entitled to avail the right of preemption as soon as the joint property is separated by deed of partition. The schedule has been given in the deed of conveyance correctly, and the plaintiff has nothing to do with it. There was no active concealment of facts and fraudulent practice to deprive the plaintiff as alleged. The plaintiff has no right to preemption as contained in the deed of partition, as the same cannot be invoked after the partition was effected by mission bounds. Also, the deed of sale cannot be cancelled, and this defendant is not bound to quit or vacate the delivered possession of the suit property to the plaintiff. The alleged notice purported to have been issued by the plaintiff has no value and so the same cannot be complied with. Under such premises, the defendant sought for dismissal of the suit with cost. Upon such pleadings, the following issues were framed for proper graduation. Issues: suit maintainability. The suit for bad for non-joiner, misjoinder of necessary parties. Is the defendant number 5 a stranger to the suit premises? Whether the clause 10 of the partition deed is enforceable after partition by metes and bounds by the by parties. Is the plaintiff entitled to claim decree for preemption in respect of the suit premises? To what other relief? Now, decision with reasons. Issue number 2, not pressed. That is a non-joiner, misjoinder. Not pressed record also does not reflect anything warranting a adverse finding on this issue. As such, the issue is decided in the negative and in favor of the plaintiff. Issue number 3. Admittedly, issue number 3 is, my lord, is the defendant of a stranger to the suit premises. Admittedly, the defendant number 5 is not a member of the family of the plaintiff and the defendant number 4, although he claimed that he was a tenant under the mother of the defendant number 1 to 4 and that she issued him rent receipt, but he has failed to file any such rent receipt. Be that as it may, the defendant number 5 is not a relative of the plaintiff or the defendant number 1 to 4, nor he is related or connected with them in terms of the blood or marriage relationship, and he is fully unknown and unconnected with them. Therefore, he is nothing but an utter stranger to the family of the plaintiff, and the defendant this issue therefore answered in the affirmative and in favor of the plaintiff. Then, my lord, issue number 1 to 4. This is important. Yes. These two issues have nexus with each other, and also in view of the trend of argument advanced by the learned advocate, are taken up together for discussions for sake of convenience and brevity, and also to avoid unnecessary repetitions. Learned advocate appearing for the defendant number 5 contended that since the suit property is not a joint undivided property, and admittedly partition has been effected by metes and bounds between the co-sharer by the deed of partition dated so and so, the same allotment have been made, the separate allotment have been made to them. No question of preemption arises, and the plaintiff is not entitled to enforce the right of preemption as provided in the said deed. He further contended that for the same reason, that is to say that since the partition has been effected between the plaintiff and the co-sharers, he is not entitled to avail the preferential right under Section 20 of the Hindu Succession Act 1956. Yet further contention was that a power of attorney holder cannot depose for the principal. Therefore, the evidence adduced by PW1, who is son of the plaintiff and power of attorney holder, cannot be accepted and attached any evidentiary value. Therefore, according to him, the right of preemption in terms of the partition deed dated 13/12/1989 cannot be enforced, and the suit is not maintainable. He cited the decisions reported in 2000, volume 8 SCC, page 330, in support of his contention. In reply, learned advocate appearing for the plaintiff submitted that since the parties have been allotted property in partition and have also been given right to dispose of the property allotted to them, with the condition that that no party shall be entitled to sell or transfer his allotment to a stranger without offering the same to the other party to the deed to buy it by preemption. Such right can be exercised by virtue of the deed of partition. When any party, without giving opportunity to other party to buy it by preemption, sell it to a stranger, He further submitted that the plaintiff is aged about 86 years and he has been suffering from various ailments, and that is why he is unable to attend the court, and as such, he has executed a power of attorney in favor of the PW1, empowering him to repose, and accordingly, PW1 has reposed. He submitted yet further that since the facts and circumstances of the present case do not exclusively belong to the personal knowledge of the plaintiff, and the principal fact in issue, that is the impugned sale by the defendant number 1 to 4 to the defendant number 5 in violation of the covenant of preemption by other co-sharer, is admitted. The prohibition upon the power of the attorney holder to depose the principal does not come into play. In the instant case, he continued to submit that the covenant laid down in the deed of partition is legal and valid, and it does not defeat any provisions of law within the meaning of Section 23 of the Contract Act. And so the plaintiff is entitled to enforce such covenant. Further, waiver means abandonment of right, and it may be either expressed or implied from conduct. But its basic requirement is that it must be an intentional act with knowledge. There can be no waiver unless the person who is said to have waived is fully informed and to his right, and with full knowledge of such right, he intentionally abandons it. Therefore, according to him, the plaintiff is entitled to the right of preemption in terms of the covenant contained in the deed of partition dated, and the suit is very well maintainable, and the plaintiff is entitled to the decree as prayed for. He relied on the decision report in AI 1971 Supreme Court 2213, AI 1979 Supreme Court 621, AI 2000 Madras 516 to strengthen his submission. Having regard to the rival contention and submissions made by the learned advocate of the in the light of the decision placed by them, and on perusal of the pleadings, evidence, both oral and well as documentary and also other, after giving a close and critical look into the other materials on record, I find that admittedly the suit property was partitioned between the plaintiff and his co-sharers, including the defendant number 1 to 4 by virtue of the registered deed of partition dated 13/12/89, Exhibit 2. And the suit flat premises being the flat on the third floor of the premises number 177D, Vivekananda Road, Kolkata 6, fell into the share of the defendant number 1 to 4, and they became absolute owner of the same. Further admitted position is that the parties to the deed of partition, Exhibit 2, covenanted that themselves not to sell or transfer his allotment to a stranger without offering the same to the other party, and to sell or transfer the same to any of the parties who would offer the highest market value prevailing at the time. And that is the case, that in case the other parties refuse to accept the same, then only the intending party will be able to sell or transfer his allotment in favor of the stranger by clause 10. It is also undisputed that the defendant number 1 to 4 sold the suit flat to the defendant number 5 by executing registered sale deed dated 15/2/1999 for a consideration of rupees 2,50,000 by the Exhibit A, and that no notice of such sale was given to the plaintiff or any other party to that deed of partition. No notice of such sale was given to the plaintiff or any other party to the deed of partition. That is to say that it goes without saying that the defendant number 1 to 4 did not make any offer to any other parties to the deed of partition before the selling the suit flat to the defendant number 5. The defendant number 5 candidly admitted that he has no knowledge about the correspondences between the plaintiff and his vendors. Also, no such document has been produced or exhibited by the defendant number 5. The defendant number 5, while deposing as DW1, admitted that before purchasing the property, he went through the deed of partition executed between the parties in the year 1989. Therefore, there cannot be any scope for controversy to accept the legal position that since there was a partition deed, there was partition between the plaintiff and his co-sharer by metes and bounds, no question of any statutory right of preemption can arise. So, question now surfaces is whether any contractual right of preemption emerges from the clause 10 of the partition deed dated so and so. In other words, it is now to be considered as to whether the plaintiff can enforce his right of preemption on the basis of such covenant contained in that clause. The law is well settled on the point that right of preemption is not a right to the thing sold, but a right of offer a thing about to be sold, and that is a right of substitution and not of purchase. That is, preemption takes the entire bargain and steps into the shoes of the original vendee, and that is that it is a right to acquire of the whole property sold and not a share of the property sold. Further, well-established position of law that right of preemption can be created in favor of the co-owners by virtue of an agreement entered into between the co-owners, and such an agreement is valid. Well, I will deal with this part further. Further, well-established position of law is that a right of preemption can be created in favor of the co-owners by virtue of an agreement entered into between the co-owners, and such an agreement is valid. I say here, for pausing for a moment, my lord, after the partition is effected, they does not remain co-owners. The Honorable Supreme Court held in the case of Srimati Vijaya Lakshmi versus Hemant Raj Chetty, and another reported in AI 1996 Supreme Court, page 2146, that right of preemption can be conferred in the deed of partition itself, and that such a right of preemption can be exercised by virtue of deed of partition when any party, without giving opportunity to the other parties to buy it by preemption, sell it to a stranger. Therefore, I have no hesitation to find and hold that clause 10 of the partition deed is enforceable and the suit is maintainable in its present form. Then, my lord. So, my lord, the decision based on the findings is entirely based on AIR 1996 Supreme Court.
Yes.
And also on the presumption or that they were still co-owners. They were still co-owners.
Mr. Section 22 Hindu Succession Act was argued by them.
Yes.
But we are not very convinced for the time being, subject to what Mr. Banerjee says, because of two reasons. Section 22 contemplates an intestate succession. Here it was by will. So that does not come in. Secondly,
yes, I have also noted in that.
It was not at the juncture when the succession, the property devolved from the ancestor, the mother. But that stage was over. This is at the stage of partition deed being executed. So that is not contemplated under Section 22. So Section 22 does not come in. The entire question is whether, what is the interpretation of 1996 Supreme Court?
Yes.
And as opposed to what judgments you will be citing also.
Well, first of all, my lord, let us, my lord, see what the 1996 says. Then I will play.
Better.
Because it is the base and foundation of the judgment.
Yes. So best way to start.
Yes. এটা কোথায় গেল? দেখো। এই আচ্ছা দিচ্ছি আরেকটা আছে কিনা দেখুন। আপনার কাছে নিশ্চয়ই আছে, আপনারা তো রাই করেছেন। হ্যাঁ দিয়ে আমার আছে 96টা
আমার আছে, হ্যাঁ ঠিক আছে।
দুটো কি নিচে 96টা আমার
Yes.
96 My lord, may I place it, my lord? From this appeal by special leave is directed against the judgment and decree dated 1/9/1970 rendered by Division Bench of the High Court of Karnataka in regular first appeal number so-and-so, affirming that of the trial court. She so-and-so Chetty stated the foster father of Srimati Vijaya Lakshmi, the appellant herein, Sri B. Hemant Pushparaja Chetty, the contesting respondent hearing, were brothers being sons of Sri Ramaya Chetty. The father and the sons effected the partition of their joint family properties under the register partition deed as detailed in Schedule A attached thereto. The father was given the properties described fully in Schedule B and to the indenture valued at rupees so and so. The foster father of the appellant got properties described fully in Schedule C to the indenture valued at rupees so and so. The contesting respondent got the properties described fully in Schedule D indenture also valued at rupees so and so. Clause 12 thereto provides a stipulation of preemption which being bone of contention reads as follows. The second, the clause 12 is this. The second, the foster father of the appellant and third, the contesting respondent hearing are allotted the immovable property number 137, 138, 139 JLS Street and 25 Virapillai Street as described in the schedule hereunder, though the party to whom it is allotted is entitled to dispose it of. He shall not do it to any stranger without giving the parties to this indenture an opportunity to buy it by preemption at the valuation given in the schedule to the indenture. The foster father of the appellant died sometimes somewhere in the year 1948, leaving his property by means of will dated 1/12/1948 to his widow Srimati Lakshmi Devamba, who also died in the year 1956. However, before her death, 1951, she as foster mother of the appellant executed a will in favor of the latter, bequeathing the properties mentioned in the Schedule C. The applicant claims to have received these properties as a foster child of Bachu Munayappa Chetty and his late widow Srimati Lakshmi Mindabha, but not a stranger. The respondent number 11, respondent on 11/12/1956 instituted a suit against appellant for possession of the aforementioned Schedule C properties of the Civil Code at Bangalore in area on the premises that under the terms of partition deed above referred to the disposition of the properties made in the manner stated above by Litson Stetty and other and after him by his widows were in breach of the terms of the partition deed and therefore his right to enforce his claim for preemption on payment of so is the price fixed here therein had ripened. The appellant put forth the two wills to assert the title as legatee. So she also claimed on a variety of grounds that neither the plaintiff respondent have any right of preemption against her, nor was such claim tenable in law. So here, after the original owner, sorry, may I proceed? Having regard to the multiplicity of the pleas raised by both sides, the trial court framed as many as 11 issues, but the relevant ones present for the present purpose are the following two issues. Number 3, whether plaintiff proves his right of preemption in respect of disposition of properties by bequest as well. Number 4, the defendant proved that the alleged preemption is unenforceable against her for reasons stated in para 4 of the written statement. After recording the evidence, the parties and entertaining the documentary evidence, the trial court recorded its finding on those two issues to the effect that the plaintiff respondent had a right of preemption in respect of the suit property, even though they came to the appellant by bequest, and that such right of preemption was an enforceable right. On holding so, and as a result of finding as on the issues, the plaintiff respondent suit was decreed directing the appellant to execute a deed of sale at the cost of the plaintiff respondent on payment of rupees 3,100 and consequently deliver possession of the premises to the plaintiff respondent. The appellant preferred a regular first appeal before the High Court. Division bench comprised of K. Mayan K. Puthuswamy, JJ, for disposal. The Honorable Judge of the High Court deferred and rendered the separate judgment. K. Vimaya J. opined for dismissal of the appeal, affirming the judgment of decree of the trial court on all issues except to the vary the price payable by rupees 36,000 as determined by the trial court for purpose of just jurisdiction on court fee. He thus ordered maintenance of the trial court's judgment and decree on payment of rupees 36,000 as price. Case Putasamiya J, however, in his opinion, took a view that findings on the issue number 3 and 4 be reversed and hence the appeal allowed. The divergence of opinion attracted subsection 2 of section 98 of CPC, and therefore the judgment and decree of the trial court got confirmed. The price rise to got affirmed on the agreement. In some plaintiff respondents got maintained the decree on payment of rupees 36,000 as price of the property. Being agreed, the appellant is before us. We do not propose to enlarge the canvas to enter into elaborate discussions and analyze as undertaken by members of the High Court bench in their respective opinion on issue number 3 and 4 relating to the concept of preemption, its historical perspective and related precedents and its validity as today and other ramifications. All same, a classic judgment of Mahmood J. in Govind Dayal versus so at page 609 is what reference which explains the right of preemption in the following words. Its right of preemption is simply a right of substitution entitling the preemptor by means of legal incident to which the sale itself was subjected to stand in the shoes of the lady in respect of the rights and obligations arising from the sale under which he has derived his title. It is in effect as if in the sale deed the vendee's name was rubbed out and preemptor's name was substituted in his place. The concept of substitution from that long and even before has been the foundation of the law of preemption and has been noticed, following and employed time and again in certain decisions, in a pattern of decisions. The fact that the court in Attam Prakash versus State of Haryana, 862 SCC 249, has struck down the right of preemption based on consanguinity as a relic of feudal past, inconsistent with the constitutional scheme and modern idea, has not altered the situation that the right of preemption, wherever founded, whether in custom, statute, or contract, is still a right of being substituted in place of the vendee in bargain of sale of movable property. We therefore need not burden this judgment with other attributes of concepts as attempted by both honorable judges of the High Court. We would rather go to decide in appeal on the basis of the contractual term aforementioned. It is noteworthy that clause 12 of the partition deed not only mention the list of the properties allotted to two brothers, but their separateness is complete and evidenced the way these properties are apportioned and demarcated and earmarked in Schedule C and D. By allocating specific properties to the two brothers, each of them had become exclusive owner of those allottees. Clause 10 of the deed and Schedule A, C, and D are reproduced there. 10. The parties 2 and 3 have been allotted this portion. Jewelry Street, the portion allotted party number 2 are marked yellow and the party number 3 red. The cost of construction of wall or walls for pardoning the said portion shall be borne by the parties 2 and 3 in equal share. The schedule so and so description. So then paragraph 12. Walls were intended to be raised to demarcate and separate the portions relating to two properties as to other two were individually allotted to the respective parties. This fallout of partition has unfortunately not been taken into account either by the trial court or the bench of the High Court. The following findings recorded by the trial court, therefore, does not match happily with the pattern of the entire pattern of partition. The entire building consisting of the portion allotted to the share of the plaintiff and to the share of the brother Bachu Munayappa Chetty forms one house. If stranger is inducted in any portion of the house, the member residing in other portion will be inconvenient to lead the peaceful life. Every house requires privacy from stranger. Apart from these, there is common passage and entrances. In fact, stormwater from the roof or of one of the parties still falls into the portion of the other party. A window belonging to the plaintiff opens into the space belonging to the other party. There are connected floors. The hall in the first floor is allotted to the share of the plaintiff, and the hall just below it is the position of the defendants. There is a staircase also tending to the first floor, and the space directly below has gone to the share of the plaintiff's brother. All these matters are such that it is not possible to lead convenient and peaceful life if a stranger is inducted to the property. But it appears, in view of these circumstances, clause of preemption was inserted in the partition deed to safeguard the peace, convenience, and amity of the family, and the insertion of such clause in the partition deed is not in violation of the provisions of the Transfer of Property Act. Therefore, my lord, I again repeat of this paragraph 1, 2, 3, 4, 5.
Mr. Shen, in this particular case, the reported
Yes,
judgment,
it appears in view of these circumstances.
two issues fell for consideration. Two were decided against the plaintiff. There, it was a foster daughter to whom it was transferred. So it was held first that she was not a stranger. And secondly, the other question which arose was that whether this disposition as per the preemption clause had to be by way of a sale. In this case, it was held that it was neither a sale nor was the foster daughter a stranger to the family. So it was turned down. So this was not a decision actually on the question whether there can be a preemption in a contract, preemption clause in a contract, but in paragraph 9, the first sentence, and paragraph 16, the last sentence of this judgment, the Supreme Court held that there can be preemption by way of statute, custom, or contract. So in this judgment, although that did not fall for consideration specifically, that whether there can be a preemption clause in a contract, but it was held that there can be contractual preemption as well. Para 9 first sentence, para 16 last sentence. There can be preemption by way of statute, custom, or contract. This is the language used.
Let us read, please, my lord, paragraph 16. Paragraph 16. Thus, for the aforesaid expressed views, we have come to the firm conclusion that on the terms of the partition deed, the contractual right of preemption conferred on the parties to buy property before it is disposed of to a stranger was based on the.
I'm sorry, the paragraphs do not tally with the SEC online version.
Oh, I see. Oh.
So then it should be, I'm telling you. No, it will be paragraph 15 in this. Paragraph 15.
Well, I have handed up the AIN 96.
I am looking at the SEC online version. So yes, look into paragraph 15. That is what is. My 16 is your 15.
Yes, yes. Next, we come. Generally, we do this. That paragraph 15 of the main book AIR or SEC.
No difficulty. Paragraph 15 of paragraph 15.
Next, we come to the question whether the disposition conceived of in the partition deed should be a sale attracting preemption, or could it also be a disposition other than sale? The word preemption as is well understood is a term of law. It is a right of substitution conferred on someone either by statute, custom, or contract.
This is the clause I am saying. This is the observation. So this is held here. And please come to para 9 also. Para 9 remains the same. Please come to para 9 also.
Just now.
Para 9.
We therefore need not burden this. Nine.
No, para 9 is the concept of substitution.
The concept of substitution from that long and even before has been the foundation of law of preemption and has been noticed, followed and employed time and again in catena of decisions. The fact that this court in Atam Prakash versus State of Haryana has struck down the right of preemption based on consanguinity as a relic of the feudal past, inconsistent with the constitutional scheme and modern ideas, has not altered the situation that the right of preemption, whenever founded, whether in custom, statute, or contract.
So this is the second place where the Supreme Court says the same thing. Preemption right can be founded on statute, custom, or contract. Here it is contract. So you have to now cite judgments to the contrary.
My lord, one thing.
Yes.
I will be advancing, going a little ahead.
Yes.
That after this, no doubt, preemption can be based on clause can be inserted or can be acted upon, even if it is by custom, statute, or contract. Now, the contract under Section 23 of the Contract Act, if it violates the law of the land.
Yes.
If it.
Which law of the land has this violated?
Article 300A, right to property.
How is it violated?
Well, I have after my vendors got the property in absolute ownership.
The right to property in the Constitution is not an absolute right. It is circumscribable and is circumscribed by at least 20 statutes. Every statute that we can get hold of regarding property transfer, Property Act circumscribes it.
To
it's not an absolute right. It's a bundle of rights. Ownership is a bundle of rights.
But
your ownership was subject to the contract.
In these types of cases, the right to property is there. In these types of cases, because this is that concept as it fell
But
from
Supreme Court holds that right to property can be interdicted by statute, custom, or contract. So it can be done.
No, by
Article
300A cannot be contradicted by, my lord, even by contract.
There is no contradiction. Where is the right of property being violated? You don't have an absolute right of property. No right of property is absolute.
That is in the sense when
let us read 300A once. 300A cannot be cited in this context.
I have not got that.
I'm reading 300A for you. One sentence. No person shall be deprived of his property save by authority of law.
Save by authority of law. Therefore,
your property devolution, you don't have an absolute right to the property. Your right to property is circumscribed by a contract. That contract is a valid contract under Section 23 because that contract itself does not curtail any right. Why, Mr. Sen, I'm telling you, by virtue of that partition deed, you did not get the property. So your property right did not devolve at the partition deed stage. The co-sharers entered into a partition deed between themselves. So there, at that point of time, you are not even an owner of the property. You are an utter stranger. You did not have any connection with the property. So your property right was not existent at that point of time. How could that curtail your property right?
I say the right of my vendors. I say the right of my vendors.
All right. Very well.
But here 300 is saved by authority of law. Now, why these particular wordings are used and employed,
Yes.
keeping in mind the law of my lord, acquisition, so and so, these
Mhm.
types of land acquisition, so and so, keeping in mind. Probably, my
Right.
lord, subject to lordship, correction from your lordship.
Yes, those are there.
Yes, that is why saved by authority of law.
All right.
Otherwise, right to property is there. Saved by authority of law employed, keeping in mind. I am repeating it, sorry.
But
But otherwise, the right to property in general
Hmm.
is there
all right. Very good.
of my vendor.
Very interesting point. Very good.
Therefore, if it curtails or it offends the law of the land, I said 300 capital A, therefore it is not a valid contract.
All
Under
right.
section 23 of the contract.
Very well.
Get to it.
Although there's a doubt whether you can take that point, whether because your vendors did not take the point.
I
But
stepped
even then
in the shoes of vendor.
So you see, by virtue of section 23, irrespective of whoever takes the points, is there. That clause is null.
Yes.
All
That is
right.
that is my whole,
This is a very
cream
interesting
point,
argument.
cream point, my lord.
Yes. All right.
Therefore, under section 23, as it is, my lord, found in the judgment also, or impugned judgment also,
Hmm.
that curtail or offend Article 300A, in general, the right to property. So, if it offends, then that clause or that contract, that part of the contract is invalid.
Very good.
So, my lord, here in this case, my lord, 1996 Supreme Court,
Hmm.
it was, my lord,
But
decided-
1996 Supreme Court is under Article 141 has binding effect. So how do you reconcile?
insofar as keeping aside the
140
contract part.
No, the Supreme
Because
Court
that was
held.
not-
Supreme Court held there can be a preemption clause in a contract. So how do you get over that?
Provided, my lord,
This
that
was the
part- that
interpretation
part
of
has not been gone into. That part has not been gone into. Contract, simplicity of contract.
As per the Supreme Court, there can be a contractual preemption right as per this judgment. That is the law of the land. Can the High Court say in division bench even that that is bad law?
I will rely upon, my lord, Honorable Supreme Court, 2000 Supreme Court.
Show
Here,
us.
my lord, here also, my lord, it is said that it appears in view of the circumstances, clause of preemption was inserted in the partition deed to safeguard the peace.
That is in the facts of the case. That is irrelevant.
The facts of the case, my lord, here.
There it was a foster daughter, so she was not a stranger and it was not a sale deed. Those were the facts of the case. Those were the issues.
But here in our case,
In your case,
in
yes.
our case, my lord, there is no chance of, my lord, leakage or, my lord, interfering with the privacy of the parties.
Privacy of the parties is not an issue at all here.
Here it is said, on the basis of that, it appears in view of the circumstances. I say in view of the circumstances. This judgment is based on in view of the circumstances. What are the circumstances differing from my case?
In view of the circumstances, what?
What, my lord? Here.
Read the entire sentence. This is paragraph.
This is paragraph, my lord, 12. 12.
Yes, in view of the circumstances.
Were intended to be raised to demarcate the paragraph 12.
Yes.
Inner page
14, our
2148.
online, my lord. Paragraph 14.
Then
12 we have got. We have got
Yes.
this copy.
the entire building consisting, have you also got it?
Yes.
Next page.
Next page.
The entire building consisting of the portion allotted to the share of the plaintiff and to the share of his brother forms one house. If a stranger is inducted in any portion of the house, the members residing in the other portion will be inconvenient to lead peaceful life. Well,
That
here-
was the ground on which preemption was being refused, Mr. Sen. But that does not have anything to do with the finding that preemption can arise from a contract. The Supreme Court is not saying in the circumstances.
I understood.
We are saying that there can be a contractual preemption.
I understood what
Here preemption was being refused in that circumstance. That is a circumstance
I was
for.
trying to distinguish the facts of this case because it was a case where there was chances of
Facts of the case are entirely different, Mr. Chen. We are not on that. But this proposition which was held there twice, that a right can flow, a preemption right can flow from statute, custom, or contract.
yes, I
Even obiter of Supreme Court is binding. This is not entirely obiter.
no, not obiter.
That was not an issue, but it was twice held. So what are your judgments? Let us see that. Those are also judgments of the Supreme Court. We'll consider whichever is more appropriate.
Very old judgment of Madras High Court, holding that.
Let us see that. Yes.
No, it's this. Let us come back. My lord. I have
Where will you
actually I
sort out
was
your
impression
judgments?
that we should not.
No, sort out and find your judgments and
No,
just
I'll get Xerox.
get at least one copy Xerox for get two copies.
I'll get it. Let us come back, my lord. Prior to that, should I, my lord, place before you section 22 Contract Act?
Yes. 23.
23.
Yes. 23 says that there cannot be any, anyway, let us.
The object of an agreement is lawful unless 1, 2, 3 is of such a nature that if permitted, it would defeat the provisions of any law.
Yes.
Okay. Well, it defeats the provisions of law, that is Article 5. Now, I am citing one full bench judgment of Madras High Court, very old judgment of decided on 17/3/1939.
এই বইগুলো এসছে বইগুলো এসছে পার্টিশন দিন বেয়ার অ্যাক্ট নেই বেয়ার অ্যাক্ট চেয়ে পাঠান
টোটাল সিভিল ল কে বেয়ার অ্যাক্ট এখানে রাখেন দুটো সেট
এক্ষুনি কাউকে পাঠান বেয়ার অ্যাক্ট চেয়ে পাঠান দুটো করে দুটোরই একজন পাঠান আর একজন দিন ওগুলো আরে এইগুলো দিন আগে ওইগুলো
এই বইগুলো দিয়ে দিন আগে
কোর্ট চালাচ্ছেন কিভাবে ইয়েস
full bench judgment of Madras High Court decided on 17th March 1939.
Right.
Right. Here it was decided whether a subsequent clause, restrictive clause, is valid or not.
Yes.
The suit was filed by the mortgagee. The short fact of the case here, my lord, that there was a partition amongst the co-sharer on 30th January 2019.
Right.
Then, in order to secure a loan, the parties mortgaged the 3 houses to the plaintiff. Part of the loan amount was paid. Then, my lord, a fresh mortgage was again executed, leaving aside some of the mortgagor co-sharer for rupees 6,000. Since that loan amount was not also paid, suit was filed for money. Well, in that case also, the defendants took the plea that there was a clause not to dispose of the property, not to sell. Then it was held by the trial court that yes, the restrictive clause is not valid. Then went up to Honorable High Court. Decree was passed by the trial court. It was decided in favor of the plaintiff. A decree was paid against the other defendants, except so and so and so. Then, in appeal, the Honorable High Court held, if we may turn to the last paragraph of paragraph 11.
Yes.
First, second, third, fourth. I hold that the restriction imposed by the deed now under consideration amounts to an absolute restriction on alienation within the meaning of Section 10 of the Transfer of Property Act, and therefore must be disregarded. Consequently, the sons took the property as tenants in common without fetter, and the 3 brothers who executed the mortgage. That part only.
Violative of Section 10, transfer power. Yes.
Then, my lord, we will be, my lord, relying on a decision of Honorable Delhi High Court, although it is by single judge.
No problem.
citation is actually আমাদের কি ছিল জানো তো 1992 Supreme Court ছিল না Delhi yeah 1992 Delhi 134 but it is from Manupatra my lord if I place the case head note family probate section so and so of Succession Act section 62 63 68 Indian Evidence Act in the law appellant challenges the rejection of the objection filed for grant of probate that was intention of the testator in having no desire to give the anything to daughters confer full title of estate left by him on his only son. Objection misconceived based on misreading section 2 failure to annex will originally probate. That is not our case now. But there, my lord, from paragraph 5, different cases were considered. From paragraph 5, internal page 2. During hearing, Mr. Lorian appearing for the appellant pressed all these contentions in respect of the first objection, namely will being void and inoperative for reasons of offering the rule against the perpetuity. The learned counsel argued that the
Rule against perpetuity is a different concept.
But there actually absolute estate was given with a rider of restrictive clause. There also when the absolute ownership devolved upon by the probate, then that subsequent clause, restrictive clause is invalid. If we may come to paragraph 15. Paragraph 15. The proposition has been laid down and endorsed in canon of authorities in a division.
Para 14, 15 and 27 are in your support.
Yes, my lord.
You can place para 14, 15 and 27.
14, 15. There is no gainsaying the proposition that in case there are unambiguous dispositive words in the will, they should be given full effect consistent with the intention of the testator, and in case any restrictive or qualifying expression is used to circumscribe the enjoyment of the device so made, then that has to be ignored as being repugnant to the real intention of the deceased. 15, the proposition has been laid down in a canon of authorities in division bench judgment of Andhra Pradesh High Court reported as so-and-so AIR 1958. Then Sangap Rapu Venkatramana Rao versus so-and-so, where the words used, the property shall pass to S. It was held that this expression was consistent with the creation of absolute interest, and any subsequent restriction in derogation of devolution is of absolute estate are to be treated as being repugnant to the preceding absolute estate.
Then come to please para 27.
Then other paragraphs also there, different high court cases are discussed. Then paragraph 27. It is noted that this judgment itself, that whole question resolved itself into what was the intention of the testator to be gathered from the will. A clear distinction was made between the case where the testator had expressed the intention to pass an estate and then added a clause against alienation, holding that in such a case only clause against alienation would be valid. But only on the facts of this case before they adopted that it was said the provisions against the alienation was confirmatory of the other part of the will. It is thus clear from this judgment that where the intention of passing of the whole estate, as in the present case, was apparent and there was only an added clause against the alienation, then only subsequent clause was to be treated as void and the bequest shall stand.
We'll also take into
other part.
We'll also take into consideration para 19 to 25.
Yes, yes.
So all those judgments are discussed. So para 14, 15, 19 to 25 and 27. Yes.
32, I am therefore in a clear view that the objection of the appellant were rightly dismissed and there is no error in the view taken by the learned district judge to the effect that present case, a case of a will where absolute title was devised in favor of the turn.
Yes.
And the subsequent condition imposed restriction on the right to sell, etc., were to be ignored as being repugnant, and this is the only view possible on a total view of the intention of the register as embodied in the will. Somewhat it is different from my earlier submission that the particular clause of the contract or partition deed is followed violative of Article 300A, but here it is predominant or the desire of the
predominant purpose of the document has to be looked into.
Yes. Subsequent.
If the purpose is to transfer absolute title, then repugnant clause goes.
So to that extent, there are difference, but the the ratio lies there that when it is the desire of the testator to give the absolute estate.
Right.
Repugnancy clause that goes. This is the Delhi High Court judgment. No, Madras High Court judgment. Okay. এটা সুপ্রিম কোর্ট সুপ্রিম কোর্ট পরে যাচ্ছে দিল্লি হাইকোর্ট এটা কোনটা দিলাম ওইটা দিল্লি হাইকোর্ট দিয়ে গেছে আচ্ছা আচ্ছা দেন মাই লর্ড This is the case where, my lord, the right under Section 4 of the Partition Act involved. Not fitting in our case or in our given case. But, well, I'm coming from. Only for one purpose. My lord, internal page. Paragraph 24 starts, we are in agreement with this opinion. 24. Page 24. We're in agreement with this opinion. Next page. There is no law which provides that co-sharer must only sell his or her share to another co-sharer. The stranger outsider can purchase shares even in a dwelling house. Section 44 of the Transfer of Property Act provides that the transferee of a share of a dwelling house, if he or she is not a member of the family, gets no right to joint possession or common enjoyment of the house. Yes. Section 44 adequately protects the family members against the intrusion by outsider into the dwelling house. The only manner in which an outsider can get possession is to sue for possession and claim separation of his share. My lord, here, my lord, because the facts of the case regarding the exercise of the power under Section 4 of the Partition Act, but I will be taking my lord, this part only, first two lines. There is no law which provides that the co-sharer must only sell her share to another co-sharer. Therefore, restrictive clause that there is no such provision in law. There is no such provision.
We agree, there is no such law.
So these are my submissions in respect of my lord. Restrictive clause.
Yes.
Now, my lord, regarding power of attorney to depose.
How is that relevant? Power of attorney deposed what?
Power of attorney deposed regarding
that there's a prior offer,
amongst others.
Prior offer, acceptance.
Yes.
So nothing hinges on that.
No, there was some.
It was your case also that it was
offered, but actually, the date of posting and date of received was after the date of execution of the sale deed.
No, if your argument is accepted, Mr. Shen, then that evidence goes. The evidence which was supporting that there was an offer and acceptance, that goes. Therefore, the position comes that there was no offer and acceptance on the part.
There is no offer.
So that doesn't help you, it goes against you. Why it goes against you? Because if there was an offer and acceptance or this stage was over, then that preemption clause would have been honored by these co-sharers, your vendor. then probably they would not have any case because that clause was honored in any event. But if there was no offer and acceptance, and if we hold in their favor on the other point, that preemption clause was valid, then there had to be an offer and acceptance. What you say, power of attorney, we also agree power of attorney cannot depose. So if power of attorney deposition goes, the position reverts back to the place that there was no offer and acceptance. And if you hold in the, if you go against them on the clause, on your first argument, then everything goes. But if we hold in their favor, then this argument of yours helps them because they had a valid clause, but there was no offer and acceptance. So your sale
But
was
there
bad.
was no offer and acceptance. That evidence to that extent or in that regard is to be ignored.
The evidence was that there was no offer and acceptance.
There was actually, in effect, there was no offer and acceptance because according to them, according to the plain case, the
No,
offer
what was the evidence of the power of attorney? That there was an offer and acceptance, or there was no offer and acceptance.
There was offer and acceptance, but that offer was made after the deed was executed. Sale deed was executed in my favor.
Achha.
May I place it, my lord?
Suppose we let that go.
There is
If
that.
that evidence is not there, then also there was no offer and acceptance.
There is no offer and acceptance.
Even after. And it is nobody's case that there was any offer and acceptance before. At least you have not proved that there has been any offer and acceptance.
No, I could not.
So at best that evidence goes. Power of attorney goes.
Then they could not establish as a whole that there was offer and acceptance.
No, but that does not help them. But that does not help you.
In the way that they could not establish their case.
If there was no offer and acceptance, how does it help you? I mean, if there was an offer and they are not claiming a right on the basis of offer and acceptance, are they? They are relying on that clause. If they had a case, if they had a case that there was an offer and acceptance, then they would file a suit for specific performance.
I agree.
So that offer acceptance, if there was no offer and acceptance, does not hinge either way. Rather may go in their favor because if they had the clause, but no offer and acceptance was made, then I mean,
Yes,
you are at fault.
Mahendra was at
You can cite the power of attorney holder evidence, but the judgments. But we'll just hold that that does not.
I have got my lord, one Calcutta High Court judgment.
You can make formally argue that Mr. Sen be very short, cite the judgment, but we will hold this.
I will only in that case.
Yes, I think we think that I mean this will not be necessary in your case.
Okay.
Very much. Thank you. Yes.
I should be candid, my lord.
No, you are candid, always candid. Yes.
Kindly takes it up tomorrow.
No, today. You have to conclude. You have already made up our mind. You have to finish your arguments today.
Mr. Auric Banerjee is leading me in the
Maybe.
matter, Lordship. He made a prayer yesterday that and Lordship was pleased to inform that in the event that Mr. Banerjee is not present due to his difficulty, Lordship will.
Well, Mr. Shen, do you seriously want to make that argument part of attorney? You can. And
no.
Well, heard learned counsel for the appellant, full stop. An adjournment is sought by the respondent, full stop. Let the matter be treated as part heard and be listed tomorrow for hearing the learned counsel for the respondent.
At 2 p.m. kindly, my lord. Because yesterday also I said that I have some personal problem. I'll try. I'll be able. Well, at 2 p.m. kindly, my lord. Kindly.
Mr. Shen, we'll only be hearing them. Somebody can take note. Yes. Let us conclude them.
Yes.
Deeply obliged.
Yesterday it fell from your lordship. Then otherwise, your lordship will have no business. But
No, thank you very much.
I thought that I will suffer loss of business.
Thank you very much, because otherwise it's very difficult. I mean, 10:30 nowadays, we fully understand the sentiments of the bar. Definitely, we were a member.
Actually, I was not willing to appear because of the resolution. But when I found the resolution that not to pass adverse order.
Exactly. And we are not passing
not to appear. That
in one order, we did not pass as adverse order. None was present. We directed service of copy even. So we did that for the appellant.
Not adverse.
No, rather favorable order. And only service of copy. But one stage was, we went one stage ahead. On the next day, we had to serve direct service of copy. So that stage is over. Thank you very much.
Your pleasure, my lord.
Thank you. কালকে আসো। এই বইটা ফেরত দাও, বইটা ফেরত দাও। ও বই। আচ্ছা দিতে হবে না দাম। আচ্ছা দেখি কি আছে ওরা। None appears for the parties, let the matter stand adjourned for the day. Next. ফাইল বার করার আগে আগে দেখে নিন আছে কিনা, তা নাহলে ফাইল বার করতে হবে।
28 will answer the respondent will this that partition suit.
Who is appealing for them?
Mr. Roy will ask
Mr. Prathapatim Rai. So he is not here.
for the appellant. But only your lordship fix it on Monday.
None appears for the appellant, although the respondents are represented through counsel. So on the prayer of the respondents, let the matter stand over till December 23, 2024. Please give your name, Seven. 29. Yes.
I am from the for the opposite party, my lord. The matter will be kept in the month of January.
Why? No, no, no. Let them come. That will be an adverse order for the appellant. An adjournment is sought. No, none appears for the appellant. Whose of an adjournment is sought by the respondent. Let the matter stand adjourned for the day. 29 ই তো হলো।
ওখানে চেঞ্জ করুন।
None appears for the parties. Adjourned for the day.
The one minute yesterday I placed before your lordship that due to non-filing of the porcha, the record of right, the learned court below has dismissed my suit for partition. Ex party. Not order 41, rule 12, sub rule 4 said, if it is ex party, even notice of service of appeal is not necessary. But till there is a direction of this honorable court that I should serve the copy of the paper book to the respondent. That was refused, but my junior has made a mistake. I must point out before your lordship. There are 3 respondents, 4 respondents. Instead of 4, he has only sent the respondent number 1 the paper book. So, may I serve the copy of the paper book afresh to all the respondents and come back immediately after vacation?
Learned counsel for the appellant, in his usual fairness, submits that there was a previous direction of court to serve copies of the paper book on the respondents, whereas copy was sent only to the respondent number 1, which has returned as refused. Full stop, next para. Accordingly, on the prayer of the appellant, the appellant is directed to serve, directed to effect fresh service of the paper book on the respondent number 1, as well as serve the other respondents, indicating that the appeal shall be listed in the monthly list of January 2025 under the same heading.
The affidavit of service be kept.
Affidavit of service filed today be kept under.
Great.
Thank you. ঠিক ইয়েতে আগেরটা ঠিক ফাইলে ঢুকিয়ে দেবেন। হ্যাঁ, এই যে দিদি ভাই আপনাকে ডাকছি, আগে ঠিক ফাইলে ঢুকিয়ে দেবেন। ওটা ভুলভাল ফাইলে প্রচুর অ্যাপ্লিকেশন ঢুকছে। আপনি না, মানে অন্য লোক করেছে। ইয়েস 31 কত হলো বোর্ডে দেখুন। 32
one for the appellant, Mr. Dutiman Banerjee, ask for an adjournment on behalf of the respondent or the this is rejecting my application under Order 39 Rule 4. I am suffering the interim order. It's a very short matter. I can conclude today, but since Mr. Banerjee is not there, it's a very short matter. The appellant's argument, your lordship can heard today itself. But I am ready.
We'll do it.
I can place my argument, and thereafter Mr. Banerjee will come and argue on the next day.
Please and ask him to check the YouTube for your order.
Yes, I shall inform.
Right. That will file.
Item number 33.
Paper book নেই?
Paper আছে,
এতগুলো পেপার বুক কেন?
একটা করেই বলে।
সব কপি ধরিয়ে দেবেন না? এটা জজের কপি, বাঁধানো গুলো। এগুলো নিশ্চয়ই রেসপন্ডেন্টের কপি হবে, বাট অন্য কেউ কপি। Have they got the paper books? So why so many copies?
But nowadays, my lord, they are securing the copies. If any appeal is preferred before the Honorable Supreme Court, they used to send my lord the paper book from
All
here
right,
itself.
all right, very good. Yes.
Now, has your lordship come? If your lordship take, my lord, there are two suits. If your lordship takes up, my lord,
Single paper book, part one. I mean, part one starts with part. Yes. Very
But,
good. Two suits.
Page 55 of my lord's brief is the
Thank you.
previous suit. Page 55.
One second. এটা আপনি কি করছেন? এটা কার জন্য? ওখানে কে দেখবে? পার্টিশনে কি দিচ্ছেন সেটা জিজ্ঞেস। আপনি নার্ভাস হবেন না। কি দুটো পার্টিশন, একটা বেয়ার একটা দিন, দুজন জজ সাহেবের দুটো হবে। হ্যাঁ, একটা ওনার উপাসে থাকবে, কেন এটা এই ম্যাটারে আর লাগবে না। ওই ওখানে। আচ্ছা, আমরা বলেছিলাম আর একটা একটা আনতে, সেটা কোথায়? সেটা দিয়ে দিন। মোটা না রোগা, মোটা না রোগা, পাতলা বেয়ার এক চেয়েছিলাম। আপনাকে বলেছিলাম আমি একটু আগে, 10 মিনিট আগে, যে দুটোরই বেয়ার একটা আনতে।
Two suits, my lord, if your lordship takes up page 55 once, but it has a genuine issue because in respect to the previous suit,
yes,
they asked for an ad interim order that was refused. They came up before this honorable court. This honorable court has dismissed their appeal with a particular finding.
What are the nature of the suits?
Yes, my lord, if your lordship takes up page 55, the previous suit plain. But they are running a school in respect of a premises.
Yes.
But where, my lord, a eviction suit is pending. That is, my lord, 2 of the floors where the school is being run.
One second, Mr. Mukherjee, this suit is still pending. This
suit
previous
is
suit.
still pending.
We are hearing appeals in connection with the next suit.
Next suit, my lord, a grant of ad interim. We filed application for vacating. That was turned down.
Both are their suits.
Both are their suits.
In the previous suit, their ad interim was refused.
Refused, affirmed up to this honorable court.
That is why you want to rely on this.
Yes. Because my, my lord, ground of suppression is based on this. If your lordship takes up, my lord, page 55, lord, this is, my lord, what I submitting, that this is a, my lord, 2 floor in respect of a adjoining where holding where I am the owner.
Right.
The suit for eviction on my instance is pending over there. Lord, there is no dispute on that. Lord, so their possession in respect of the school building being run is not disputed. What they are asserting, their right in respect to a certain, my lord, lawn, Lord, of a different premises, Lord, that they are seeking that they are the licensee in respect of that lawn, which used to be a playground by the school. That is their case. If your lordship takes up now 1 or 2 paragraph of the plaint, I shall take your lordship thereafter the prayer, page 58. Paragraph 6. That in fact, the student of the plaintiff society have been using the said lawn and or world fenced compound as a playground since the year 1974 on the basis of the permission given by the Karnani Properties Limited, being the defendant number 1. It would be apparent from the aforesaid letters dated such and such and the letter dated January 21, 1974 that Karnani Properties granted permission to the plaintiff society to use the said lawn as a easement attached to the said premises wherein is situated Harrow Hall School. In fact, if the nature of use of the various portions of Karnani Mansion compared with the use of the said premises as a school for children was considered, it would be found that the said playground and or lawn was for the benefit and enjoyment of the said premises, which was dominant heritage, and the said playground and or lawn was the Servian heritage. It would also be found that the Karnani Properties Limited were the servient owner. The various portions of the Karnani mansion were used mainly business purpose, to which tenancy a playground would have no use. The enjoyment of the playground would mainly by children, and the largest group of children were the student of Harrow Hall. That in or about March 2014, the plaintiff society was shocked and surprised to find that the principal officer of the Karnani Properties Limited have fixed a signboard on the said lawn bearing the word, "This property is under the possession of the joint receiver appointed by the Honorable High Court at Calcutta." So, Milord, this is the different aspect. So, this is the cause of action and this is their plea. What is the prayer, Milord, if your lordship takes up? Page.
Mr. Mukherjee, the solution is possible. School playground.
But what I have, it's really an adjoining premises where, Milord, it's an exclusive ownership of my client. That is not, Milord, even the playground used for this school. This is something, Milord, they want that so that, Milord, my client cannot exploit that portion of the property, because if anything come up in that portion, the building where, Milord, the school is being run, Milord, maybe, Milord, some air or light will be blocked. Milord, that is, Milord, the main reason.
School after all.
School, Milord, I know, but Milord, this is something, Milord, where, Milord, my client is really a owner, and this is not even a playground. This is an open, Milord, area where at a park street. Milord, if your lordship consider that aspect also. Milord, it's the eviction suit is pending in respect of the school premises, that is other thing. I am not, Milord, on that. Really, the school is being run in respect of an adjoining premise. And they are running the school, Milord, in the second and third floor of that premises. It's not that the entirety of the building, so that, Milord, they can get access from the ground floor itself. Ground floor is not, Milord, within their tenanted premises. Then also, Milord, since your lordship, Milord, I shall take instruction to further effect what. But what is the prayer, Milord?
No, they'll have to pay up for that. I mean, not for gratis.
Yes, Milord, that I shall take instruction.
Not for gratis.
Yes.
Obviously, will commercially exploit it, but they cannot match that probably. But if something in between is possible, let us hear the matter. No difficulty on that.
Milord, page 73 is, Milord, the prayer. On this backdrop of facts, Milord, he prayed a declaration that the plaintiff has easementary rights of being allowed to use the said lawn and or playing ground more fully described in the schedule below by the students and teachers of the plaintiff. A declaration that the plaintiff is a licensee. My lord, kindly marks, Milord, this licensee under the defendant number 1 for use of the said lawn and or playground more fully described in the schedule.
So they're admitting its permissive position. It's their case also.
That's Milord, what is, Milord, the injunction, that permanent injunction restraining the defendants from interfering and or restraining the students and the teacher of the plaintiff from using the said lawn and or playground. But if your lordship turns over the page 75 is the schedule.
Yes, that playground or lawn.
Yes, what is the said playground and or lawn referred to herein above is situated near the school premises. Now your lordship will get, it's not, Milord, the part of the, Milord, premises where the school building is being run. Near the school premises at the southern angle of the Karnani mansion, along with the southeastern side of the road running from the southern gate to the eastern gate of the carnally mentioned, which is used at a number of premises. It is something for which this portion is necessary for the purpose of going the vehicles also to reach the other portion of the carnally mentioned. So it's not that it's an open area, but it's this area is getting access for my other premises.
It's a concrete place or a grassy place?
No, it's
not grass.
That is the instruction. I shall take that instruction also. Exactly. In this suit, an injunction application was filed. Page 78 of my lords.
Yes.
There, page 98 is the prayer for injunction.
Right.
The ad interim injunction in the tune, as prayed, in the.
Yes.
Now, if your lordship takes up page 115. So this is the refusal of the ad interim. Your lordship straight away comes to page 117. I am not troubling your lordship regarding the entirety. On hearing, the third paragraph of page 117.
Yes. What it?
On hearing, learned lawyer, and also on perusing the documents filed by the plaintiff, it appears that there is no dispute that the plaintiff is not at all the owner in respect of the said lawn/playground, though the students and teachers of the plaintiff school are all used the said playground of lawn with the permission of the defendant, and thereafter the defendant was compelled to fix a signboard that the property is under the possession of joint receiver appointed by the Honorable High Court at Calcutta. So under such circumstances, it appears that at the matter at the matter is now pending before the Honorable High Court, and moreover, as the plaintiff failed to prove prima facie case, so prayed for interim injunction of order of injunction is considered and rejected at this stage. So basically, since the matter is sub judice, there is an appointment of receiver, so the court refused to pass an ad interim order in their favor. They
What is the context? What is the background of this receiver case?
That is regarding the another suit. Payment of rent. That is the directors' dispute in another case.
Directors between themselves.
Between the
directors of Karnal.
For which this receiver is being appointed in respect of this property. This property is not part of their tenanted premises. So for which prompted me to affix the board over there. Now page 120 is the order passed. By this honorable court. This order is important. I read the order. The first miscellaneous appeal is directed against an order being number 2 dated such and such, passed by the learned Judge 5th Bench Civil Court at Calcutta, entitled suit number such and such. By the said order, the plaintiff's prayer for ad interim injunction was refused by the learned trial judge. Hence, the plaintiff felt aggrieved. The instant appeal is filed by the plaintiff appellant challenging the legality of the impugned order. Let us now consider as to how the learned trial judge was justified in refusing the grant of ad interim injunction in favor of plaintiff in the facts of the instant case. Here is the case where we find that the plaintiff appellant has claimed its permissive possessory right to use the suit lawn as playground of the students and teachers of the plaintiff school. Though certain documents regarding grant of such permission allegedly used by the defendant number 1 was annexed to the injunction application, but no document has been annexed to the injunction application showing that the plaintiff in fact was in possession of the disputed lawn as on the day of filing of the suit and or the date when they sought for such ad interim injunction. So the Honorable Division Bench is conscious. They tried to rely upon some document, some letters by virtue of which the creation of license they want to rely upon, but they could not able to prove the possession in respect of the premises in question on the day of filing of the suit. Under such circumstances, we do not find it appropriate case where the ad interim order of injunction should be passed. Kindly turns over the page. Accordingly, we hold that the learned trial judge did not commit any illegality in refusing to grant ad interim order of injunction. Mr. Such and such learned advocate appearing for the appellant prays for leave to file supplementary affidavit for bringing the document on record to show that the plaintiff is in possession of the suit law. On his prayer, we grant the plaintiff a week's time to file such supplementary affidavit before the learned trial judge. The plaintiff is also directed to serve copies of the application for interim injunction and the supplementary affidavit, if it is so filed, upon the defendant within a week thereafter. The defendant respondent are permitted to file affidavit in opposition to the plaintiff said application for temporary injunction before the learned trial court within 2 weeks from the date of service of copies of the plaint, etc. Upon the defendant respondent reply, if any, to be filed by the plaintiff appellant within a week thereafter. Now, my lord, the usual direction, my lord, for speedy disposal of the injunction application. So your lordship has already noticed that the Honorable Division Bench has not interfered with the ad interim refusal on the pretext that though the letters were there, but regarding possession, no documentary evidence has been filed for the purpose of not grant of any ad interim injunction. After this, my lord, observation of the Honorable Lord Division Bench, the learned advocate representing the school will not have sought for an liberty to file a supplementary affidavit to rely upon certain document by virtue of which the school authority can show his possession in respect of the property in question. That liberty was granted. So, my lord, it is a conscious attempt in the second, my lord, first suit. My lord, till today, my lord, my specific instruction, my lord, that there was no affidavit, supplementary affidavit filed in connection with that previous suit. Now, what they have done, this all have happened, my lord, in 2015. So 14 suit, 15. Now, my lord, if your lordship takes up the present suit, page 1 of my lord's brief, paper book. I shall take your lordship to the application for injunction, the pleadings to some extent. But if your lordship takes up now, my lord, the texture of the new suit, page 12, the prayer starts. Declaration that the plaintiff having...
So entirely has been read.
Yes. So, my lord, a school who has sought for his right to be adjudicated as a licensee, creation of license, they sought to be relied upon, possession could
Bad
be...
advice. Bad legal advice. They had documents to show license was permission was given.
That is their case.
And they had section 116 of the Evidence Act with them. Because you have to show that the relationship was severed.
But here, my lord,
they destroy their own case. What can we do?
Kindly see, my lord, now page 16.
Yes.
What is the, my lord, suit property? It's my duty to point out before your lordship that the same thing.
Yes. When was this filed? This suit?
This suit was filed in 2021. And if your lordship takes up page 19 onwards, the injunction application. That kindly takes up page 31, paragraph 31 of the injunction application. I could have understood, my lord, by this passage of time, some new facts have been propped up, which, my lord, prompted them to file a new suit on a different texture. But kindly see, my lord, the conscious statement even in the present suit, page paragraph 31, that so far as the easement right to use the said lawn and playground of the said school, Harrow Hall School, the petitioners have derived the said right from the year 1974.
Therefore, no new circumstance.
Yes. And till now, the students of the said school of the petitioner number 2 are regularly using the said lawn for their various physical activities. By virtue of the permission, you kindly see the same tune, same letters used for two different purposes. But regarding the possession, my lord, kindly see paragraph 32 also, that from the year 2013, the Darwans of the defendant opposite party frequently offered obstruction for the students of Harrow Hall, being the petitioner number 2. So it's
did not mention the previous suit at all.
No, nowhere.
That suit is still pending.
That suit is still pending.
Even if it is not pending, they should have disclosed, but this is bad sharp practice. Nothing anywhere.
No, my lord.
Yes, nothing. We have seen.
That prior to 5th of July 2021, there was a mild obstruction offered by the Darwan. That is, my lord, the cause of action.
And the previous suit was filed when?
Previous suit, my lord, was filed 2015.
So after 2013?
Yes.
After this cause of action?
Yes. Same cause of action was shown in the previous suit also. Now only a obstruction from a Darwan in 5th of July 2021. In this suit, my lord, after the service of summons, my lord, we took out an application for vacating.
Ad interim was granted.
Ad interim grant. Vacating এর পাতাটা বলো।
Vacating was refused, which you were challenging.
Yes. And my lord, I am protecting by an order from this court that till the day of disposal of this appeal, my lord, the injunction application should not be heard on merits. Because otherwise, my lord, this appeal will become infructuous.
There should not be such an. I mean, the appeal becomes infructuous. Ad interim, this order 13 and rule 4 does not affect the final hearing of the injunction.
But my lord, in reality, my lord, whatever the possible grounds we could have urged, we have already.
That order could have been passed instead of restraining it.
So, the learned trial judge ultimately, if is not satisfied with regard to whatever ground I have.
It becomes infructuous. You challenge the last order, and then it will be tagged with this.
That's why, my lord, I pray before this honorable court that on the coordinate bench, my lord, that since we have all possible ground we have agitated, so it's really a contested injunction. It's because.
But then the injunction continues also.
Injunction continues.
So you have you're acting like Kalidas.
No, my lord, after
the injunction, if the injunction application was disposed of, then it might have been vacated by now. And Mr. Chaudhary advises that it should be the injunction should be.
It's not that. But if your lordship takes up once, my lord, page 42.
Yes.
Page 42 is my application.
Page 42 is your application. That new appeal could have been heard out by now, probably. Against the final, if the final injunction was granted, we probably could have heard out that.
Only difficulty is that
at the admission hearing,
all those grounds. It's really a injunction application which was heard out.
Your choice, you have obtained an injunction that was granted also. The injunction will not be heard till disposal of the order 39 rule 4 appeal.
No, not order 39 rule 4, but yes,
yes, so this is an order 39 rule 4 appeal.
Yes. But here, paragraph 5 at page 44, I have specifically mentioned about the
suppression.
Yes, suppression.
Yes. Suppression is a valid ground under 39.
Now, that takes up the order reviewed once. But at page 126.
Last year only.
Yeah, this is.
Yes, 126.
19th of
126 is the last impugned order. Present.
Yes.
Great. Yes.
It appears from the record that both the sides were heard at length on the petition under Order 39 Rule 4. Today is fixed for order. This application under Order 39 Rule 4 read with Section 151 of CPC has been filed by the defendant number 1 with the prayer for vacating the ad interim order of temporary injunction dated such and such, granted to the plaintiff on the plea that the plaintiff has filed the suit and the petition for temporary injunction by suppressing the material fact, and the plaintiff has filed a prior suit on the self-same property on the similar reasons in the year 2015, being titled suit number such and such, which is still pending before the court, and the plaintiff did not disclose the said fact, and they did not approach this court with clean hands. The plaintiff contested the petition by filing written objection by denying and disputing all the allegations made in the said petition, and inter alia stated that the plaintiff was compelled to institute this suit due to the illegal activities and pressure mounted by the defendant number 1 on the plaintiff in respect of the suit property. At the time of hearing, learned advocate appearing on behalf of the defendant number 1 submitted that the defendant number 1 had no plan to raise any multi-storied building on the suit premises which is a lawn open to the sky, and the plaintiff has filed this suit without any basis and by suppressing material fact, and he prayed for vacating the ad interim order of temporary injunction already granted to the plaintiff. On the other hand, it is submitted by the learned advocate for the plaintiff that the plaintiff is in permissive possession of the suit property for a long time for beneficial enjoyment of the school, and the defendant has no right to encroach over the said right to the plaintiff, and he prayed for rejection of the petition. Now, Miller, it's important. Kindly turns over the page. On perusal of material placed on record, it appears that an allegation has been leveled by the plaintiff that the defendant number 1 is trying to raise a multi-storied building on the suit property, which is admittedly, kindly marks this portion, Miller, admittedly in permissive possession of the plaintiff, and the ad interim order was granted by this court, video order number 4 dated such and such, for protection and preservation of the said suit property. And since the defendant has failed to lay particulars of alleged suppression of the material facts on the part of the defendant, the petition under order 39 rule 4 of CPC fails short of any requirement. Miller, admitted possession, where from the court founds, Miller, it's an admitted position only on from record.
You have also annexed the ad interim order passed in the second suit. Thirteen 9/2021 order.
Yes, Miller. No.
No problem.
That order was not.
Anyway, very well. So this is your appeal.
This is by appeal, my lord. The court's observation with regard to the admitted permissive possession, in my respectful submission, my lord, it's contrary to the record. Not only that, it's contrary to the previous judgment of this honorable court, wherein this honorable court specifically and categorically found that the plaintiff could not able to prove possession. And on the basis of that finding, liberty was sought for, so that he can, my lord, rely on certain further document to prove his possession. In spite of that, that was not, this opportunity was being granted, not availed of in the previous suit. New suit on the same set of facts. The learned judge is saying, Lord, this is an admitted possession. But it's, this finding is perverse, my lord. It's beyond the record, and also, my lord, the contrary to the judgment passed by this honorable court. If that be so, my lord, and this is the ground on which, my lord, I am contesting the injunction application itself.
Who is appealing for the other side?
Mr. Parthapratim Roy is leading, my lord, the Mr. Ganesh.
We have heard it.
This is not my submission, my lord. Let Mr. Roy come and finish it, my lord, on Monday.
Heard learned counsel for
Only,
the...
my lord, in presence of Mr. Roy, I shall cite one judgment, my lord, on the point of...
Cite the judgment and tell him over phone. But tell him today itself.
Yes, today itself,
You-
my lord,
you-
I shall inform. My lord.
Either any of you, please just inform me.
Yes, my lord, it's settled, but still, my lord, 2010, volume 14, SCC, page 38. If it's as abuse of process of law, my lord, paragraph 21 to 30, my lord, I am relying upon. Then, my lord, this is, my lord, equitable relief cannot be granted.
Clean hands.
Clean hand. Lord, even if, my lord, if it is an educational institution, I say, my lord, they should have been, my lord, with much caution, my lord, being a litigant, they should have taken, my lord, a proper way to, my lord, ventilate their grievance. This is not a way, my lord, by virtue of which they should, my lord, ask for an equitable relief.
Order ki pass kore dichi. Heard learned counsel for the appellant. Pushed up. Since none appears for the respondent at the time of call, comma, let the matter stand adjourned till tomorrow for arguments by the respondents.
Lord, it's surrounded by boundary wall. It's concrete one, and it's kind of a driveway also. So
You have surrounded subsequently.
This is there.
But that never came on record before Justice Bhattacharya, Justice Jyotirmoy Bhattacharya, or before that. You never took that point. In your appeal, you never took that point.
No, Lord, in the previous appeal, ad interim challenge, Lord,
If it was surrounded, then
surrounded, Lord, by
in that
a
order
gate.
39 rule 4 you have stated. It should have been there. If it's surrounded, that should be one of the
That is
great
the
points
present
of.
picture, my lord, but in order 39 rule 4 also, my lord, the ground is mainly on suppression, my lord, what I.
If that is not there on record in order 13 rule 4, it had to be there. Because that would be a good ground also.
48.
That would be another material fact which would be suppressed then. No, actually,
Yes, definitely.
that is also material. If they claim easement right, if it's surrounded by a wall, school is cut off, there cannot be any easement right. That is the most material fact. If it was in your there in your application, should have been discussed. Although the court
Lord, I
might
shall
not.
check it up, Lord, if.
No,
Lord,
check
I
it
have-
right. Check it up right now. Where is the 39.4?
Yes, but this page 42. No, my lord, there is no averment with regard to that, my lord.
Even if there is a hint, we'll just check. No. No. There is nothing, sir.
No.
Nothing of that. So we'll hear tomorrow. Inform Mr. Rai and inform this judgment.
Yes,
to him.
Lord, both this, my lord, I shall.
So that he can come prepared and we.
Tomorrow your lordship is getting singly, so no, tomorrow.
Tomorrow Thursday. Tomorrow we'll take very
Tomorrow.
much take him.
Very.
Next.
Great.
Thank you.
Your Lordship, I am appearing on behalf of the respondent. One prayer, Your Lordship, appellant is not appearing, but I am led by Mr. Shobhajachi Chaudhary in this matter. If it can be kept after reopening of this court.
Very well. None appears for the appellants. Full stop. Learned counsel for the respondent seeks an adjournment till after the upcoming Christmas vacation. Full stop. Accordingly, let the matter stand over till after the said vacation and be listed in the monthly list of January 2025.
Right.
You said this on the last occasion also. We remember. Yes, we remember. None appears for the parties. Adjourn for the day.